Hello, everybody, and welcome back to Agree to Disagree. We are very, very happy to have you here. I'm really excited because last week we were having this brilliant debate, and we had to cut it short, sadly, and I was sad about that. So I'm happy to see it resume. I'm really excited to see this resume because it's something that I've been looking into for many years. So, hello, cats.
Hello, how are you doing? That was a nice intro.
Yeah, it's a weird thing. I'm starting to kind of get used to it. I don't think I ever will. I think it would be dangerous if I did. But yeah. How are you doing?
Yeah, I'm looking forward to this as well, to be honest, and for different reasons than you. For me, it's a topic that I know so little about. I don't really, politics really isn't my thing, especially anything to do with American politics. Obviously, I know very little about, but the whole idea, the bit of the debate that we did get last time. For those who don't know, we had to cut it short. There was internet connection problems, but the bit of the debate we did get last time kind of sparked enough questions in my head that I thought this is a really interesting topic. I don't necessarily have an opinion to share, but I definitely want to hear some more on it.
OPT lawyer is asking if we will be starting over. I think it's only fair because the big problem with that original one was David's internet issues. It's all sorted now, thank gosh. So yes, we will be starting from scratch because obviously the original one has been privated. People have been asking why it was privated. It was privated because it was unfair to the debaters and to you guys that you didn't get to hear the proper debate. So that's why it was privatized. There was nothing bad that happened. There's no drama. The first thing people were like, did something kick off? No, nothing kicked off. I promise.
Yeah, over here.
So yeah, we'll be starting from scratch.
One thing I should say, and I didn't mention it last time, is that the format of today's debate has been agreed by David and Marc before they even came to us, and it's a little different to usual format. So I'll just run you through it. I didn't do that last time; it caused a bit of confusion. Essentially, after the 12-minute opening from either David or Marc, whoever goes first, the other person will then just have a 5-minute sort of cross-examination on anything they've said in that opening before they then do their own opening. So after every little bit of a section, there is going to be an opportunity for a cross-examination from the other person. Adding up all the time limits, I think we're going to be quite strict on them. It shouldn't last much more than an hour, maybe an hour and 10. We'll see. So yeah, just I thought I'd mention that. That's it, really. Should we bring them in?
Yeah, we'll bring them in. And just to say, afterwards, we are going to have a little bit of a discussion. Both Marc and David have agreed to allow the likes of OPT lawyer, Tusk if he's around, and Nate the lawyer if he's available to come on, just to have a little conversation about what is the realities of working in that field around the issue of plea bargaining. So cool. With that, we will bring on David and Marc. Hey guys.
Hey. Hello, good to see you guys.
It's good to hear you. Good to hear you clear and crisp this time, mate. Good to have you back. I can't remember last time who went first or whether we decided we'd stick with the same format. Have you two had a chat about who's going to go first this time?
It'll still be David.
Yeah, I'm the affirmative, so I'll go first.
Okie dokie. And do you want to I have put links to your social media in the description, but do you want to give yourself a quick introduction before you kick off?
Sure. I would love to give them a little bit of an introduction. So my name is David. I am a student at the University of Maryland, Baltimore County. Oops, sorry.
Go ahead.
Sorry. So yeah, I'm David. I am a student at the University of Maryland, Baltimore County. I am studying biochemistry and molecular bio. I am passionate about science, and I'm also passionate about human rights and politics. I am very involved with Maryland state politics, and I am currently running for re-election to the Central Committee, and I am currently carefully considering a run for a Maryland state delegate. So that's a little bit about me. On my YouTube channel, I do a lot of discussions on science, do open discussions, and debunk young Earth creationist and all of that type of fun stuff. So last night I had a really good conversation with Jordan on nuclear power. You should totally check that out.
Brilliant. Mark, do you want to introduce yourself, mate?
Sure. So my name is Marc Pollock. I have a PhD in microbiology and a background in food safety. I currently work in Chattanooga, Tennessee, though I'm from California, if you can't tell based on the lack of a Southern accent. And I have been doing debate for a long time. I still teach debate online to elementary schoolers, and I'm really looking forward to this debate.
Fantastic.
Right. Well, I've got a stop clock, Crafty, if you want me to monitor the time.
Yes, please.
I think we said 12 minutes for the opening, didn't we? And then a 5-minute cross-examination. So I'll get that set up while you do your thing and launch the debate.
Right, and so just before we launch the debate, what I'm going to do is I am going to put up a community tab for all questions. If you do have questions and you can't get to the community tab, then tag me into your questions and I'll try keep track of them as much as I can. So with that, David, if you want to take it away.
Yeah, I will definitely begin. Excellent. Thank you, Dr. Marc Pollock, for agreeing to debate me on this topic, and thank you, Conspiracy Cats, for hosting me. I am super excited for this debate. Why are we debating this topic? This debate topic was the January-February 2018 topic for the Scholastic Tournament debate from Speech to Debate. So both of us are interested in this topic, and so that is why we decided to debate. With that, I affirm the resolution. Plea bargaining ought to be abolished in the United States criminal justice system. For clarity, I offer the following definitions. Plea bargaining, an arrangement between a prosecutor and a defendant whereby the defendant pleads guilty to a lesser charge in the expectation of leniency. Ought, indicating a moral obligation. Abolished, a system, practice, or institution formally put to an end. Criminal justice system, the system of law enforcement that is directly involved in apprehending, prosecuting, defending, sentencing, and punishing those who are suspected or convicted of criminal offenses. The affirmative plan will give defendants an option to plead guilty to crimes they are charged with, but will ban prosecutors for offering incentives to plead guilty. The value premise that I wish to present this morning is the value of justice, the maintenance or administration of what is just, especially by the impartial adjustment of the conflicting claims or the assignment of merited rewards or punishment. Justice, of course, is the most important value in the justice system, and the criteria that I offer for justice is the doctrine of proportionality. The punishment must fit the crime. In Solem versus Helm, the Supreme Court ruled that we must compare the nature and gravity of the offense and the harshness of the penalty, compare the sentence imposed on other criminals in the same jurisdiction, whether more serious crimes are subjected to the same penalty or to less serious penalties, and compare the sentences imposed for commission. I'm sorry? Okay. Compare the sentence imposed for the commission of the same crime in other jurisdictions. And so, in other words, when all else are equal, we ought to give the same punishment for the same crime. The criminal justice system has several main goals: protect the innocent, punish the offender, rehabilitate the offender, and deter other crimes. Contention number 1, plea bargaining violates the criteria of proportionality. The United States Constitution guarantees defendants the right to a fair and impartial jury in due process. When prosecutors offer the defendant a plea deal, they attach what scholars call the trial penalty. If you dare exercise your rights under the U.S. Constitution, you will be given a far harsher sentence than if you accept our plea deal. This is coercive and a blatant violation of proportionality. The National Association of Criminal Defense Lawyers notes, quote, the trial penalty refers to the substantial difference between the sentences offered in a plea deal offered to trial versus the sentence a defendant receives after trial. This penalty is now so severe and so pervasive that it has virtually eliminated the constitutional right to a trial. To avoid the penalty, accused persons must surrender many other fundamental rights to which are essential to a fair justice system, end quote. The Cato Institution writes, quote, as Americans, we should be deeply suspicious of a criminal justice system in which people almost never choose to exercise their constitutional right to a jury trial. The fewer trials there are, the less opportunity there is for citizens to participate in the process, and the less transparent and accountable our criminal justice becomes, end quotes. Indeed, to give an illustration of how disproportionate these sentences are, here are some statistics. Defendants convicted of drug offenses with mandatory minimum sentences who went to trial to receive sentences on average 11 years longer than those who pled guilty. Among first-time drug defendants facing mandatory minimum sentences who had the same offense level and no weapons involved in their offenses, those who went to trial had almost twice the sentence length of those who pled guilty. And finally, among defendants who were eligible for a sentence enhancement because of prior convictions, those who went to trial were 8.4 times more likely to have the enhancement applied than those who pled guilty. Any system that effectively punishes a defendant for using their constitutional rights is an unjust system that must be abolished. Contention 2. Plea bargaining fuels systematic violence. The United States is home to less than 6% of the global population, yet the land of the free and the home of the brave is also home to the largest prison population in the entire world. The United States is over-criminalized. Because of the unjust war on drugs, millions of Americans have criminal records for victimless crimes such as marijuana possession. To illustrate how unjust our system is, from the years 2015 to 2017, we had more marijuana possession arrests in our country than all other violent crimes combined. Allow me to repeat this statistic. We had more marijuana possession arrests in our country than all violent crimes combined. All of this is fueled by the plea bargaining system. Our system cons defendants into giving up their constitutional rights to a fair and impartial trial in exchange for a more lenient sentence. Danny Whale notes, quote, as long as plea bargainings are used as a club to coerce defendants into advocating their rights of the Constitution guarantee of a free trial, the present industrial complex will continue to grow exponentially. Plea bargains are one big woodpile that serves to fuel the ever-expanding present industrial complex, rendering transparent the American political resolve to incarcerate more and more people, even if it means bankrupting their municipalities, cutting education, and devoting their budgets to subsidizing the for-profit present industry. If plea bargainings were eliminated, or severely monitored and reduced, the states and federal government would then be required to carry out their burden under the Constitution of proving the guilt of criminal defendants in accordance with the law. If this happened, there would be a whopping reduction in prosecutions, not to mention incarcerations. Such a shift would be an important step in ending the current carousel culture of mass confinement and cruelty, end quote. There is good empirical evidence to support this. When Alaska began plea bargaining, quote, the pre- and post-ban rate of conviction for white defendants was unchanged at 53%, while the post-ban rate for non-white defendants dropped 6 percentage points from 55% to 49%. Additionally, examination of particular crimes indicated that the decrease in conviction numbers can largely be attributed to the decrease in convictions for low-level crimes, end quote. Contention 3. Plea bargaining causes miscarriage of justice. Subpoint A, it causes false conviction. Imagine this scenario. You are arrested for a crime you know you did not commit. You have two options. Number 1, take a plea deal for a lesser charge and or sentence. Or 2, go to trial and possibly get convicted and get a harsher sentence. Which do you choose? For many innocent people, option 1 is a logical option, especially if you cannot afford an attorney and cannot afford cash bail. Plea deals are one of the leading causes of false convictions. The Innocent Project noted that of the 227 wrongful convictions overturned by DNA testing, 27 of those pled guilty to the charge in order to avoid the death penalty or harsher sentence. Moreover, they note that at least 31 people pled guilty to serious crimes like rape and murder to avoid long sentences to avoid trial. These innocent people served a combined total of 150 years in prison. In the case of Robbie Day Dixon, they pled guilty to a 1979 Mississippi rape and murder they did not commit. After the two men were threatened with the death penalty, they testified against a third innocent defendant. Further study shows that 18% of exonerees pleaded guilty, and of those, 65% were people of color. If these are the statistics for serious crimes such as rape and murder, how much more are Americans? How much more Americans are in prison or have criminal records for crimes they did not commit? Subpoint B: plea deals protect rapists and sex offenders. Plea bargaining protects rapists and sex offenders and discourages victims from seeking justice. Rachel Williams notes, quote, hundreds of convictions gained in rape cases are actually for lesser offenses. Only 38% of rape cases won a conviction for rape itself. Alternative convictions were generally for offenses such as sexual assault or sexual activities with a child under 16, a much easier charge to prove because consent is not an issue. Alternative convictions come about because of plea bargaining, where a rape or murder, more likely attempted rape charge, is dropped after the defendant offers to plead guilty to a lesser sexual offense, or because the jury is given two alternative charges and convicts on the lesser one, acquitting the defendant of rape. Campaigners said that reduction of rape to a less serious offense was a kick in the teeth for victims. The sentence will be lower, the man will be out sooner, and the victim may also get less or even no compensation. The rapist will be confirmed in his view that he can get away with rape and is more likely to do it again. When a charge of sex with a minor is used instead of rape, it can be particularly harrowing for the victim because it suggests that she consented to the activity. Samantha Schnitz also notes, a former Indiana University student who was charged with rape in two separate cases accepted a plea deal in which both felony charges were dismissed and was sentenced to a year's probation with no prison time for a misdemeanor. The former student, John P. Enochs, spent only a night in jail. Last fall, before posting bail, was met with outrage on social media. It also drew comparisons of a recent case in which a Stanford University student, Brock Turner, was sentenced to 6 months in jail by a judge after being convicted of sexual assault. The case reflects the complexities that often arise in campus sexual assault cases when alcohol blurs memories and evidence becomes too ambiguous to prove rape. Mr. Enochs pled guilty to one count of battery, which with moderate bodily injury. Prosecutors have sought a felony charge, but because of Mr. Enoch's age and lack of prior convictions, a judge reduced the charge to a misdemeanor. The most frustrating aspect of
50 seconds left. Sorry to interrupt. Just
okay,
like 50 seconds to go.
Okay, sorry. According to Rain, 13% believe that the police would not do anything to help, and 2% believe the police could not do anything to help. So to conclude, the resolution of this morning's debate asks us whether or not we have a moral duty to abolish plea bargaining. The U.S. has a moral duty to abolish plea bargaining because it violates the criteria of justice, fuels systematic violence and injustice of the system, and causes extreme miscarriage of justice. Our system is deeply broken, and we must fix it from the inside out. Plea bargaining is just one piece of the wall of injustice that must be dismantled. The resolution is affirmed. Thank you.
Wow, 10 seconds to go. 10 seconds to go. Look at that. Brilliant. Some really positive comments in the chat about that as well. People thinking you're putting a strong argument forward. Well done. Crafty, have you spotted anything you want to mention before we let the cross-examination start?
No, well, there's a few things that we can come back into because some of it is from OPT lawyer and Nate is here as well now. So we'll have a really interesting discussion as well after. So yeah, it was a very, very good, strong case.
Brilliant. Yeah, no, it certainly was. So for those watching now, Marc will have a 5-minute cross-examination of that before he then gets his own 12-minute introduction. So a slightly different format to what we're used to. Are you ready, Marc, if I hit start?
Yes, I'm ready.
Okay, off you go.
So, David, first of all, good speech. 2 questions. If people are still allowed to plead guilty, but they don't have any benefits for doing so, who's going to plead guilty?
Most likely the people who know they're guilty and just wanted to get it done and over with.
But they're not going to get any benefits to doing so. Doesn't that mean they'll want to try and challenge it as much as possible?
Well, even if they do, that's a good thing because they're exercising their constitutional rights to a jury trial.
Okay. So how do you know that this is coercive and not a choice on the part of these people who are pleading?
Because it is inherently coercive when you have either you plead guilty or you're going to go further into jail. When you're pleading guilty, we have multiple examples that I gave in my opening case where people pled guilty for the very purpose of avoiding the death penalty, and two people who were threatened with the death penalty had to testify against the third defendant. This is inherently coercive. If it's not coercive, then why are they pleading guilty to avoid the death penalty?
So is any benefit coercive?
In fact, I would argue yes, it is coercive, because we're basically saying if you dare exercise your rights, you're going to be given a far harsher sentence.
So if any benefit is coercive, then why would there ever be a case where someone could reduce charges even in court? If they get a reduced charge in court because they did something to improve the circumstances of the case, or even said something about someone else, why wouldn't that also be coercive? That's not a guilty plea either.
Well, again, because in a case, I would argue that it is inherently coercive.
But that happens in a trial, doesn't it?
Yeah, well, you're still offering them a bargain. You're basically saying, if you do this, then we're going to reduce your case. That is still coercive.
So by that, does anyone have any incentive to say something that might open up the case on someone else?
That's a good question, and I don't know the answer to that. Probably not. They might not have an incentive unless they are remorseful and want to get everything done and over with.
So you said a lot about systematic violence and how these unjust laws lead to a lot of problems. Doesn't that speak to the unjustness of the laws themselves, like the war on drugs, rather than the plea bargaining system?
Oh, absolutely, and I agree that part of the problem is the overcriminalization. And as I contended in the opening speech, this does tie back into plea bargaining. Prosecutors are able to churn out case after case, and it frees up other resources, and it encourages them to keep going after these low-level crimes. When you have a system where 97% of the people don't even go to trial, if people were to actually use their constitutional rights, it'll probably slow down the courts more, and eventually prosecutors will have to pick and choose which cases they're going to charge, which cases they're going to actually charge, and which cases they're going to drop.
1 minute.
Isn't there two sides to this coin, though? Isn't it not just the prosecutors that have to decide how to allocate their time, but the public defenders?
You can say that, but again, that's more of a problem with the system as a whole. And I contend, of course, that plea bargaining is part of the problem that fuels these issues. It's basically it fuels this fire, so to speak.
Also, you talked a bit about how this sends more people to jail. Are you aware that guilty pleas are typically result in a fine or probation and not prison?
Yes, most of them are probation and stuff like that, but many others are not. It does ultimately lead innocent people to go to jail, and it also ends up with innocent people accepting a plea deal and end up having a criminal conviction for the rest of their lives.
Okay.
Sorry, that's 5 minutes. Stop that. Yeah, 5 minutes. So could you hear that beeping?
No,
I cannot. I can
A
hear
little
it.
bit.
it doesn't work when you're on mute, Cats.
No, I just wonder whether it was because it was on a browser, whether it was whether it would feed into the call, because I'm that technologically proficient. I know that kind of stuff. Right, so note to self, I need to somehow find a way so you can hear the beeping. Right, okay, so that was a cross-examination. Crafty, have you seen anything in the chat you want to address before we move on to Marc's opener?
No, there's a few people talking about the debate in general, saying that it's a good debate. I think it was a pleasure bargain that let Epstein walk free the first time, says Brian Bridgewood. So, there are some really interesting things being talked about in the chat, but not really relevant to the debaters. So again, if you want to have a question for the debaters, there's a community post and it's linked. Link is the wrong word. It's pinned. It's pinned. The comment is pinned, so you can jump on and put your questions there. So we'll ask them later.
And I will, before I just bring Marc on, because I don't want to forget, we will read it later on. Traveller X, before we started, like 10 minutes before the stream started, dropped a super chat. So I just want to thank him for that. And we'll get that read out later on. But thank you so much. Okay, so should I start a timer for Marc's 12 minutes?
Yes, please.
And just a reminder, for those who've turned up late, if you want to check out either of these guys, the links to their social media are in the description. Marc, when you say your first word, I'll hit start.
All right, good to debate this, and let's get started. It is because I recognize the need for people to receive justice rather than wait interminably for it that I oppose the resolution. Plea bargaining ought to be abolished in the United States criminal justice system. My value is justice, like my opponent, but justice is often defined as giving each their due, which is appropriate here as well. Those who are jailed for a crime are due the capacity to address their circumstances in a timely manner. My value criterion is autonomy. Individuals are and should remain free to relinquish the right to a jury trial when a waiver is in their best interest. To constrain the autonomy of the accused is in this context would disregard fundamental liberties, rendering them incapable of affecting their circumstances. This leads into my sole contention, court clog. According to the International Center for Prison Studies, at any given time, roughly 480,000 people sit in America's local jails waiting for their day in court. These are people who have been charged with a crime but not convicted. They remain innocent in the eyes of the law, and 1/3 of felony defendants were not ultimately convicted of any crime. These people served months in jail without a trial. In many areas, that wait can be even longer. Some 400 inmates in Rikers Island waited over 2 years for their trial. Often they are forced to wait simply because they can't afford to post bail. A 2013 analysis by the Drug Policy Alliance found that nearly 40% of New Jersey's jail population fell into this category. The Bureau of Justice Statistics found that among felony defendants in the nation's largest counties, 34% were detained before trial because they couldn't make bail. Plenty of people sit behind bars not because they're dangerous or because they're a flight risk, but simply because they can't come up with the cash to post bail. The consequences of a pre-trial detention, even a brief one, can be disastrous. Miss too much work and you're out of a job. Fall behind on your rent and you're out of a home, too. A 2013 study by the Laura and John Arnold Foundation found that even short pre-trial detentions were linked to bad outcomes, not just for defendants, but for society as a whole. Among low-risk defendants, for example, those who were held in jail for 8 to 14 days before trial had a 51% greater likelihood of reoffending after completing their sentences than those who have been held for less than a day pre-trial. Finally, many of the people who can't afford to post bail are living on the margins of society. A short jail stay is all it would take to trigger an avalanche of repercussions: lost job, lost house, that could force them to turn to public assistance to make ends meet, in some cases indefinitely. And all these problems are exacerbated by increased overcrowding in these facilities, which are already overcrowded. This already overtaxed system will be dramatically overwhelmed in the absence of plea bargains. 97% of cases are settled by plea bargain. State-level data suggests similar numbers nationwide. This would yield a massive increase in the number of people awaiting trial, many of whom would sit in jail because they cannot afford bail. Plea bargaining can cut costs and delays. Without an incentive to plead guilty, even defendants facing overwhelming evidence may decide to take their chances in court. A plea bargain can even offer an immediate route out of jail that simply wouldn't be there in its absence. So what happens if plea bargains are taken away? We have case studies on this. Between 1975 and 1990, they were banned in Alaska. Even then, they happened informally. Judges made implicit deals with defendants who pleaded guilty. One study found that the sentences after trials for violent crimes were, on average, 445% longer for than those given after pleas. For fraud, they were 334% longer. The Texan city of El Paso banned plea bargaining in 1975. During the following 2 years, the trial rate doubled, and the 2 judges assigned to the criminal cases could not cope. 10 more were assigned to help them, but even so, prosecutors started to strike secret bargains with judges' encouragement. Even when trials happen, the circumstances would be made far less just. Curtailing plea bargaining would also threaten disastrous consequences for the broader criminal justice system. For example, limiting pretrial negotiation would almost certainly lead to a dramatic surge in the number of trials. In order to cope with the systemic pressure of the multitude of new trials, courts would need to pare back their length and scope, resulting in the curtailment of rights and an increase in the rate of false convictions. And these would come without any of the reduced sentences that plea bargains can yield, which contrasts with courts where mandatory minimums set a baseline. This is particularly problematic for the poor, who are often reliant on underfunded and overworked public defenders. Public defenders are, as a general matter, the hardest working sect of the legal bar. But our nation's public defender system has long been plagued by underfunding and excessive caseloads. In Florida in 2009, the annual felony caseload per attorney was over 500 felonies and 2,225 caseloads. That's per public defender. In Florida in 2009, the annual felony caseload per attorney was, actually, that's just what I said. According to the U.S. Department of Justice in 2007, about 73% of county public defender offices exceeded the maximum recommended limit of cases, which is 150 felonies or 400 misdemeanors. Too often, those who are poor receive lower quality defense than those who have the means to pay. The ongoing decimation of public defense prevents defense attorneys from conducting core functions, including factual investigation of the underlying charges. Overworked and poorly prepared attorneys were unable to provide effective representation to those they counsel, in violation of their ethical obligations to provide competent and diligent representation and their clients' rights under the Sixth Amendment. More court trials exacerbates this, while plea bargains offer a solution. Problems allocating scarce resources plague public defenders just as much, if not more, than prosecutors. Bringing losing cases to an efficient conclusion allows them to focus greater attention on more demanding or deserving matters, perhaps involving innocent defendants. And because even private defense counsel often earn relatively small fees, plea bargaining may provide the only path to adequately represent their clients and still make a living, and for the criminal defense bar to continue attracting talented attorneys. As for defendants themselves, those convicted at trial had no right to leniency in the first place, rendering the ability to bargain beforehand a welcome boon. This means that Pro's case takes a system that is already failing the poor and dramatically worsens it. They are forced to wait out a clogged court system, sitting in jail, unable to earn money for themselves or their families, and effectively receiving punishment without a conviction. When they do get their day in court, they are reliant on the strength of a public defender system that is already woefully inadequate for managing the slew of cases that go to trial right now. Plea bargaining offers opportunities for leniency and representation that disappear in its absence. These impacts spin off to affect far more than just the poor. First, a clogged court is inherently detrimental to justice and communities. Courts play a critical role for our nation and our communities. They are the infrastructure of justice, just as important to the rule of law as roads and bridges are to transportation. Yet delays in the current system have already yielded reduced capacities to seek justice in cases involving discrimination, civil rights, predatory lending practices, consumer fraud, immigrant rights, environment, government benefits, business contracts, mergers, and copyright infringement. The American people and our federal courts cannot afford existing unnecessary and damaging delays, yet Pro's case dramatically exacerbates them. Backlogs mean justice delayed in cases involving protection of individual rights, advancement of business interests, compensation for injured victims, and the enforcement of federal laws. They erode confidence in the court's ability to uphold constitutional rights and render fair and timely decisions. Delay in the federal courts puts people's lives on hold while they wait for cases to be resolved. Businesses face uncertainty and costly holdups, preventing them from investing and creating jobs. Second, removing plea bargaining as a tool hampers justice. By getting rid of plea bargaining, Pro affords no means to address other big problems like white-collar and organized crime. For these, pleas are necessary. These are the most conniving and hardest to catch. The government is in a poor position to provide incriminating information without that inside help. Plea deals are necessary to convince people to become early cooperators in investigations against corporate cartels or groups which collude to reduce market competition. As O'Brien, an attorney for the Antitrust Division of the U.S. Department of Justice, explains, in the U.S., early cooperators not only provide valuable evidence that the division can use against other co-conspirators, but also once their plea agreements are filed on the public record, they often provide strong momentum that expedites the division's investigation and prosecution of other conspirators and even other cartels. There is extensive evidence that this process has been very effective. Over the last 20 years, over 90% of corporate defendants charged with an antitrust offense have entered into plea agreements with the division where they admitted guilt and cooperated with the antitrust division's criminal investigations. There are numerous examples of cartels that have been brought down partially as a result of plea bargains, including the vitamin cartel, which involved companies colluding over how much each product would produce, each company would produce, to how much they would charge, to which customers they would sell to, affecting the pocketbook of nearly every American consumer who took a daily vitamin supplement or had a bowl of cereal in the morning.
45 seconds to go.
Plea agreements resulted in a slew of cases and resulting criminal fines up to $875 million and prison sentences for individual executives. There are dozens of other examples, from graphite electrodes to lysine and citric acid to marine construction, transportation, and even explosives. Plea bargains were instrumental in bringing each of these cartels down and sending the message to others that the U.S. government would find them and hold them accountable. With that, I yield the floor to my opponent.
That 10 seconds left as well. That's pretty well timed. Pretty well timed. What do you think of that, Crafty?
That is fantastic. I did have to laugh. Brian Bridgewood just in the chat. Everything would be fine if it wasn't for all the naughty people.
True.
It is just good to break that kind of ice because I mean, again, it's heavy with just incredible stats. And there's a judge somewhere who uses the plea bargain very, very effectively. And what he does is instead of sends people to jail, he makes them, like, I think at one stage he made a woman sit in a dump for 15 hours or something because she left her dog in the house for like a week.
Oh.
And instead of sending her to jail, he said, you know what? You'll understand if you actually had to smell what he had to smell for a couple of hours. Like, so it can be used very effectively. And
wow.
Yeah.
Oh, that's I like that kind of justice. I do. We've got the cross-examination now, and you've got 5 minutes, David, to cross-examine Mark, and then we go into the rebuttals. So, shall I start the stop clock?
Whenever I ask the first question.
I think you're on mute there, David, mate.
Oh, I do apologize. So, Dr. Pollock, the criteria is the autonomy of the defendant. So, when a defendant is given a choice between pleading guilty or giving the death sentence, doesn't this necessarily reduce the defendant's autonomy?
No, I don't think it does, because their only other choice is to wait in jail for their day in court, which is going to be expansive if you remove this option.
Okay, so how do you propose that we reduce the waiting time for the people's day in courts? How do you propose we do that?
Plea bargaining.
Plea bargaining, but we already have plea bargaining and we still have all of these problems. Doesn't this tie back into the over-criminalization?
We could talk about all number of other ways in which you could resolve this problem, but they're beyond the scope of the topic. I would say that we need to do what we can to keep the system running somewhat efficiently and not advance problems with inefficiencies.
Okay, so when defendants are given such disproportionate sentences for going to trial, doesn't that reduce justice overall?
I'd say what reduces justice overall is not getting your day in court or having to wait longer in jail. Sure, there's some room for discussion about whether changing the sentences that they get is disproportionate, but I would say that that represents a need in society to resolve these problems rather than an actual disproportionate problem.
Okay, but still, if plea bargaining is inherently coercive, wouldn't that reduce the autonomy of the defendant?
What we have to recognize here is that we're not talking about plea bargaining or everything's fine. It's plea bargaining or you wait until you get your chance in court with a public defender who's already massively overtaxed. I would say that having a choice is better than having none.
Okay. How much time do we have left on the cross-examination?
2.5 minutes.
Okay, sure. So you mentioned that people have a much higher chance of pleading guilty. Those who it fuels the cycle of going to jail and offending. What do you propose we do to reduce that?
I hate to repeat myself, but keep plea bargaining.
Okay, but when an innocent person accepts a plea bargain, that inherently gives them a criminal conviction, and would that reduce their chances at getting a job and might eventually make this innocent person more likely to commit a real crime?
I'm not saying the system's perfect. I don't think there is a way to make the system perfect. That being said, if you're stuck in jail for a long period of time without the ability to see anyone in trial, you're out of job anyway.
Okay, so by eliminating stuff like cash bail and stuff like that, wouldn't that reduce some of the issues with that?
Again, beyond the scope of this debate, but yeah.
Okay, fair enough. And as I said in my opening round, plea bargaining is just one piece of the puzzle that fuels this systematic violence.
Okay.
Okay. How much time do we have left on the cross-examination?
About 40 seconds.
All right. I think I'm just going to go straight into my rebuttal round if you're okay with that.
Yeah. Shall I just explain to everybody what the format for the rest of the debate is?
Yeah, sure.
I'll just get it up on the screen. So they've agreed this before between themselves before they've come on. So they're now going to have a rebuttal to each other's opening statement, and then that will be followed by a 5-minute cross-examination. And then we just go into a 3-minute closing statement and we're done. So, Crafty, is there anything you want to say or anything you want to respond to in the chat before we launch into that?
We now have Tusk in the chat as well. So
Hey,
Tusk was a lawyer too. So it's great to see. First of all, I do want to thank both the debaters for the excellent presentations, because it's so important to actually, the whole purpose of a debate is to get the information out. So they did that very, very effectively. And yeah, people are enjoying it. So yay.
Yeah, you both come prepared. You both know what you're talking about. You're both willing to structure it in a format where the other person can speak. Makes our job a lot easier. So thank you for that. I'll start the stop clock. 8 minutes, isn't it, David? The rebuttal, yeah?
Yep. Awesome. All right. So my opponent's call criteria is the court clog. So in order to address this contention, we must begin by looking at what is clogging our courts. Our courts are clogged primarily due to low-level crimes and immigration. Remember what I said in my opening speech. More people were arrested for marijuana possession than all violent crimes combined. Again, more people were arrested for marijuana possession than all violent crimes combined. This takes up valuable time, money, and police resources that are better spent elsewhere. All of this ties back to my contention that plea bargaining fuels this systematic violence. When prosecutors can turn case after case through plea bargaining, the quality of our courts go down, and it encourages police and prosecutors to continue to go after these low-level crimes. All of this does far more harm than good, and there is good empirical evidence to conclude that this causes a decrease in public safety. Lawson et al. Notes that, quote, although the frequency of arrests for low-level crimes has long been used as a tactic to reduce crime and serve as a deterrent, these types of public nuisance or quality of life arrests may also have negative effects on public safety for two reasons. First, because they harm police-community relationships, and second, because the time spent in incarceration may take detainees more likely to commit crimes after release. This is something that my opponent admitted in his opening case. Frequent arrests for low-level offenses are often viewed as unjust and discriminatory. As a result, they decrease trust in police and the criminal justice system and beliefs and their legitimacy. Research shows that the residents of highly policed communities may be less likely to report crime and to cooperate with law enforcement. Paradoxically, such policies may even increase the likelihood of some individuals committing crimes, in addition to the problems related to the decreased trust in the police. The loss of employment and the difficulties involved with obtaining gainful employment may make engaging in criminal activities upon release more likely. Furthermore, family and community connections may have been eroded, while connections to others involved in criminal activity will have increased simply due to the fact of incarceration. McArdle notes the following. The most obvious way to begin repairing this broken system is to spend more money building courtrooms and hiring judges so that defendants actually do have a chance at their constitutionally guaranteed right to a speedy trial. We should also take a long, hard look at the number of things that are crimes and the sentencing laws that are required in many crimes be requited with very harsh penalties. Most of our mass incarceration problems is a sentencing problem driven by both mandatory minimum sentences and prosecutors who are rewarded for being tough on crime. These factors aggravate the flaws of the plea bargaining system. Prosecutors can threaten to prosecute on draconian charges, which carry draconian sentences, and all but force the defendant, even an innocent one, to take a plea bargain with a lesser charge and a lesser sentence. Defendants, guilty and innocent alike, are usually concluded that the risk of going to trial is simply too great, and the plea bargains in turn keep the machine from choking on the volume of cases being run through it. Instead, it grinds out a very poor substitute for justice, reducing the number of laws and reducing the ability or requirements for prosecutors to secure serious jail time for so many offenses would reduce mass incarceration and start to unclog our systems. end quote. My opponent's criteria for justice is the autonomy of the accused. When the accused are forced to accept a plea bargain in order to leave jail or avoid a harsher penalty, this inherently reduces the autonomy of the defendants. So, in other words, my plan, the affirmative plan, actually does a far better job of upholding my opponent's criteria of justice. Remember what I said in my opening speech. I said several examples where people who were innocent pled guilty in order to avoid the death penalty and avoid harsher penalties. Allow me to repeat what I wrote in my opening statement. Because defendants convicted of drug charges with mandatory minimum sentences received 11 years longer than those who pled guilty. And as I mentioned in my opening case, we had several cases of people, 227 wrongful convictions that were overturned by DNA testing. 27 pled guilty to avoid the death penalty, and after 2 men were threatened with the death penalty, they testified against a third innocent defendant. This, of course, reduces the autonomy of these defendants and reduces the criteria of justice that my opponent provided. How am I doing on time? Can I get a time check?
Yeah, you got 2.5 minutes left.
2.5 minutes, great. So, let's see here. What else do I want to write down? So, yeah, most of the stuff that he wrote in his opening case, I already addressed in my opening round. So, I'm definitely looking forward to hearing what. I'm definitely looking forward to hearing Dr. Pollock's response to my opening case. I'm looking through my notes for one other thing. I'm looking for something that I know I wrote down. So while I'm looking for that, I conclude, of course, I affirm the resolution that plea bargainings are one of the leading causes of these systematic justice. Remember what I said, more people being arrested for marijuana possession than all violent crimes combined certainly increases the issue of court clogging and court cases. We need to take a holistic approach at what is causing our court clogs and systematic violence. This resolution asks us whether or not the United States has a moral duty to abolish plea bargaining. And because plea bargaining does fuel the systematic violence and does fuel this mass incarceration, then the obvious answer to this question is yes, we do have a moral obligation and a moral duty to
1 minute.
Abolish plea bargaining. I'm looking for one thing. How much am I doing on time?
Yeah, 1 minute, mate. Well, just under, about 50 seconds now.
Okay. I'll see the rest of my time and I'll find it for my next speech.
Okie dokie. I shall stop that. There we go. Right, I'm echoing. Crafty.
Hello. There has been a lot of discussion out in the chat. A lot of people talking about you have to take it from case to case. Derek Jensen was saying that it's either a felony possession or it's not. So discretion. I think it's a discussion that they were having. And Tusk, interestingly enough, says plea bargaining is about to have its day with the grand jury calling witness against the Trump organization. Minor operatives will be offered reduced charges in return for flipping. So, yeah, there's a lot of discussion going on there. So you've got people thinking, which is always a good thing.
Definitely, it's not clear. It's not a clear-cut thing, is it?
No.
All?
No. And that's why it's reflected there in the chat. So many people, we have someone who was convicted and is giving his say, and it's great that we have a range of people actually giving their opinions and their experience. So thank you.
Well, we now have a 5-minute cross-examination of that rebuttal before we reverse, and then it's just the closing statements left. So, Marc, as soon as you say your first word, I'll hit go.
Good responses. I'm going to ask a number of different questions, but I'll try and keep this one short. How does plea bargaining or the absence thereof affect police behavior?
Because it encourages them to go after low-level crimes such as marijuana possession. And as you admitted in your opening statement and the evidence that I provided, by going after these low-level crimes, stuff that probably shouldn't even be crimes, are converted into the civil cases instead of criminal cases. This has a negative effect on public safety, and it has a negative effect on community's trust in police. By abolishing plea bargaining, prosecutors, in order to unclog these courts, are going to have to pick and choose which cases they're going to try. Is it really worth taking up valuable police resources and time and money and bankrupting municipalities over low-level crimes such as marijuana possession, and instead should we focus on more violent crimes? The goal of the police, what the police and the law enforcement needs to do, is do a better job going after the violent crimes, such as murder, rape, and all of that other stuff. And instead, we should begin.
Let me interrupt you for a moment. Why would police do fewer arrests?
Well, I'm sorry. Can you repeat that?
Because what you're insinuating there is that police will arrest fewer people for marijuana possession or whatever crimes. Why would removing plea bargaining accomplish that goal?
Because eventually prosecutors and state governments are going to have to say, okay, it is not worth our time, it's not worth our money and resources going after marijuana possession. I do think it's very problematic when we have more marijuana possession arrests than violent crimes put together. All of these victimless crimes certainly clog up the courts, and by removing those things as crimes or converting them to civil cases, or just not prosecuting them altogether, certainly solves for the harms that
are you aware that many states are legalizing marijuana now?
Yeah, that's a great thing. And I think that part of that issue, part of the things that are starting to make states, sorry, 1 second, I'm getting a phone call that I need to, I'm trying to, here we go. Sorry about that, guys. So yeah, eventually I think it's a great thing that states are legalizing marijuana, and I hope it goes on the state level as well. And I think part of the reason that we're legalizing pot is because we're starting to realize that these stuff like marijuana possession is not worth going after, and all of this is doing far more harm than good.
So, okay, are you aware that prosecutors are often paid more for more convictions?
I'm sorry, can you repeat that?
Are you aware that prosecutors are often paid more for achieving more convictions?
Yeah, I am aware of that. And again, part of that goes back to plea bargaining.
I'm asking you, what incentive do they have to reduce their caseload?
They have the incentive of reducing their caseload by ultimately, first of all, I think that's a great point. I think we should, one of the ways we can fix that is by not giving them incentives to reduce their caseload, and by not giving them extra pay for more convictions. Ultimately, though, I think that plea bargaining system is encouraging this system by, if you're a prosecutor and you're getting paid to turn out case after case after case, offering a plea deal is a great way of doing that. If you're offering plea bargains and threatening people with draconian sentences, that is inherently going to make you, as a prosecutor, more money.
30 seconds.
Okay, I'll end off here.
Okay. Right. There we go. Sorry, my battery's going on my keyboard. I can't switch windows as quickly as I want to do. Crafty, is there anything you've seen in the chat? Anything you want to address or say? Or?
There's a few coming out of the woodworks now, especially with that last little section. OPT is not a happy boy, apparently. He does say on several occasions, he says that's not true, and I
Yeah, if
hope
it's not,
that he's.
if it's not true, I certainly hope it's not true.
I'm gonna make a statement about that.
Yeah, I hope he gets on to actually give, because he has taken both of you very, very seriously and written lots of notes, because that's what lawyers do. And then we have Nate saying, as a former prosecutor, I can say for a fact that you are not paid more for convictions. It is unethical.
Yeah, and I agree that it's inherently unethical. And like Dr. Pollock, if Dr. Pollock is wrong, then I would love to hear the evidence for it. Prosecutors are not paid more just because they're getting more convictions. I certainly hope that's the case. And Dr. Pollock, I know this isn't part of the debate itself, but what evidence do you have to support that?
I don't think he heard you there, mate.
Yeah, Dr. Pollock, are you there?
I'll get to it in my actual speech. I don't want to introduce evidence here.
Okay, yeah, that's fine.
Well, we're going to that now. So you've got your 8-minute rebuttal, followed by your 5-minute cross-examination. As soon as you say your first word,
so who's going first? Is it David?
I'm sorry?
Is this David or Mark? Yeah, okay.
Mark's rebuttal. And then David will cross-examination him. Cross-examination him. That was good English, wasn't it? We'll cross-examination him. I'm educated as well. Okay, Mark, whenever you're ready, I will start.
Okay, I'll start now. So I apologize. I misstated something in my questioning. I meant to say that there's an incentive to get through more cases, not to get convictions. So to actually get through the process of the case rather than secure a conviction. That is my bad, and I'm sorry for stating it that way. So I'm going to engage in some rebuttal, first of his case, and then also some case defense. So to start, there's this criterion that he is using in this case that does not make a whole lot of sense to me. He's essentially stating that the doctrine of proportionality is what we should be going for in every case. What he's missing in this argument is an understanding of why we should want to change what the actual charge is for so many people. In doing so, we achieve more justice in the process. And this is something he didn't respond to from my case. This white-collar crime and cartel response that is really important towards addressing a lot of criminal activity. If we follow this this doctrine of proportionality, we lose out on addressing one of the major criminal enterprises in this country on the basis that no one's ever going to have much incentive to actually push for this kind of thing. They don't have a reason to plead against someone else for any reason. Sure, that might lead to some instances of people not selling out someone who's actually innocent, but in the process, it also leads to all the guilty people essentially not having any means to address them. Remember that the prosecution in those cases has effectively no tools to take these people down, whereas at least in cases where you have someone innocent who's getting reported on by someone else, they still have to provide actual support for that claim that they did that particular crime, which means there is room to actually address that. So if that's happening, that's something that is preventable under my case. It's not something that he can account for in his. So beyond that, there's this main argument that's been going on here that it's coercive to use to use plea bargaining. And I think this fundamentally misunderstands why autonomy is so important. What he's essentially offering as an alternative is you get to await your day in court that may never come. Remember, we're talking about 2-month wait times right now, on average, with some people going as over 2 years in terms of wait times. Imagine adding 97% of all cases to that load. All of a sudden, you have to increase the amount of people who have to go to trial, and that means that you have to address this in a much bigger way. Now, he talks about spending more on courts and judges, but it's unrealistic to argue that we will increase the amount of infrastructure we have to account for an additional 97% of all cases. What is currently going on is only 3%. You're talking about a massive increase in the amount. This isn't something that you can do just by papering over the problem. Beyond that, he doesn't address the fact that guilty pleas typically result in a fine or probation. This is really important because he talks a lot about how there's a lot of overcrowding in prisons and jails, but he does not address that this is one way to address those problems in some meaningful fashion. Obviously, it does not do the job fully, but what he is changing over to is now all these people will be stuck in jail until their appointed court date, which may be years down the line. So he is increasing the amount of people in prison well over what is available right now. So the problem that exists right now is going to get much worse under his case. It is better to have this kind of system in place than to delay trials to a ridiculous extreme, which is really what his case is doing. All he's doing is forcing them to stay in jail for a much longer period of time. He's reducing their ability to make autonomous choices that can affect their prison stay and go back and actually, work or pay off their houses or do anything that needs to be done in order to preserve their life outside of that prison system. Now, what Pro is doing a lot of in this debate is he's trying to wave away a lot of these problems. He's essentially saying, well, if we do this, then people will feel the need to change policies. He does not give you much of an explanation for how that would work. Getting rid of the system of getting rid of plea bargains doesn't mean that police officers are all of a sudden going to stop arresting people who are possessing marijuana. They have a reason to go after people who are actively going against the law. It does not make a difference to them whether the courts are clogged. Now, it might make a difference to prosecutors, but and I'll point this out, it also makes a difference to public defenders who are already massively overtaxed. So what Pro is effectively doing here is he's throwing a big wrench into the system in the hope that that wrench will stop it so hard that people are going to change policies. But there's so many different people involved in this that he can't possibly guarantee it. The legislature isn't going to do something magically because the judiciary is overtaxed with a whole bunch of other cases. This could go on for years before the legislature decides to do anything, and it's unclear that they would do any major changes that would actually affect these kinds of policies. And not to mention that many of the policies that he talks about are ending now. Legalizing marijuana is happening in many states. Many people are already changing these policies. If this is such a great thing to have happen, it is non-unique because it is happening in both of our worlds.
1 minute.
So really, all the benefits that he talks about for police and community relations are dependent on a change in police behavior that he does not justify. These changes require that everyone see this judicial problem and respond perfectly to it. I can tell you from my experience watching the legislature work and watching how various groups respond that they don't all tend to agree on what the best avenue is for doing this. If the police decide not to do this, then they'll just jail more people that the prosecutors have to find some way to get through, and the public defenders have to be able to defend to the same degree. And they're doing it with far fewer resources than the prosecutors have. That is a terrible loss for these people, and it's going to affect their rights to a deeper degree than plea bargaining could ever manage.
That's time if you just want to wrap up with your last sentence.
That's it.
That's it. Wow, you did that bang on this time. You're timekeeping, you guys. I don't know how well you've researched these. Rehearsed these, but your timings have been absolutely bob on, guys. Well done. Right. Why can't I see anyone else on the stream? Am I on mute?
No.
No. Oh, I'm just looking at the wrong window. I'm having a technical problem. Right. While I'm sorting this out, Crafty, is there anything you want to say?
No. Is that the debate done, or?
No, there's a cross-examination
of
Marc, and then 3-minute closing argument each.
Grand. There is a lot of talk in the chat. Yeah, it gets higher as you go on. Tim, part of that is passion. Then when people are talking with passion, that's what happens. You go up an octave. So that's not new.
Yeah, that's something I just generally do.
Yeah, I do the same thing. I do the exact same thing. But yeah, there's people are telling their experiences in the chat, which is fantastic. Absolutely encourage that. There's someone that took the ISAP but decided to go into business. The parents were lawyers. One of them, a judge. My uncle was a lawyer for a large city. So yeah, we have a lot of experience in the chat. So keep that up. Let us know.
Yeah, definitely. I'm definitely looking forward to hearing some of the comments from the lawyers. So we have one more cross-examination round, and then 3-minute closing, and that's pretty much it.
Mm-hmm. Yeah. So you've got 5 minutes to cross-examine. Then we'll say we'll do your 3-minute closing statements. So as soon as you say your next word, David, I will start the clock.
All right, sure. So one thing that I don't think you addressed really for my opening case is the issue of coercing people to to coercing people to causing false confessions. Do you believe that plea bargaining helps people cause confessions?
To some degree, yes, though I would also say that massively overtaxed system with public defenders who can't provide adequate defense, and especially if they're running through cases faster, which they almost certainly would have to in your case, I would say that also leads to a lot of false convictions.
Okay, so I'm talking about false confessions.
I would say false convictions are even worse because the cases actually lead to more time spent in jail.
Okay, so for false convictions, doesn't a defendant have a better chance of, if a person is innocent and I plead guilty and accept a plea deal, and evidence later comes out that proves my innocence, isn't it better that I get convicted at trial rather than pleading guilty? Are you aware that it's easier to have a false conviction overturned by if you don't accept a plea deal versus if you accept a plea deal?
I would say that if you're dealing with a massively overtaxed system, one that's even going to be more overtaxed by this process, then you're also going to have a lot of trouble getting through that. But I think the more important thing here is to recognize that the confession is coming from a person who is making the choice to confess. I would say that their willingness to do so changes the game in this.
Okay, so why are people confessing to crimes they didn't commit?
Because the alternative is to spend extensive times in jail.
Okay, but if they're going to spend more time in jail and they're going to falsely confess to a crime, doesn't that take away their autonomy, which is your criteria of justice?
Again, they're making the choice to plead. They're just as they'd be making the choice to go to trial. In your case, there is only one choice: sit in jail until your day in court. I wouldn't say that involves much autonomy.
Okay, so autonomy, you define. Can you repeat how you defined autonomy?
Sure. So, back up. So I defined autonomy contextually. I said individuals are and should remain free to relinquish their right to a jury trial when a waiver is in their best interests.
Okay, sure. So by getting rid of plea bargaining, or excuse me, under the plea bargaining system, people are often don't have this autonomy that you're proposing.
I'd say they more often have it because they have the choice to plea or to go to trial than they would in your case.
Okay, so you said that you're often pleading guilty, false confession, because the alternative is spending months and months in jail. How do you propose that we fix that? Doesn't that have
there are a lot of possible fixes, but they're really not relevant to this debate.
Okay, sure. So they're not really relevant. Since you said the alternative is spending months in jail, if we were to fix that, if we were able to fix this, wouldn't it be a good thing to abolish plea bargaining? If we do fix the issues of spending months and months in jail?
If everything else was perfect and we assumed that there are no other problems, then it's plausible that you could get rid of this option. But that assumes a perfect system that doesn't exist.
Okay, sure.
10 seconds.
Okay. And I do apologize. I didn't get to. I was focused on the other things. You mentioned witnesses, plea deal, solving crime. I didn't quite get to that. From my understanding, it will be poor conduct on my part to address that in my next round. Correct?
So is that to me or Mark?
That was to Mark. Do you mind if I address that in my next speech, or?
I mean, you're allowed to rebut.
Okay.
I don't see why not.
Okay, sure. I do really want to take time to address that point because I think that a point is important.
So we are at pretty much the end of the debate. First, we've got three-minute closing statements. Crafty, is there something you wanted to do with the chat? So I was seeing
there is. So there have been questions and comments come in. So I'm just gonna from the community post and one or two that I've noticed. So I wanted to wait until just before the conclusions. So FE peer review says not exactly a question, but rather an issue I hope they'll address. When a crime involves several defendants, offering a plea bargain to someone lower on the totem pole in return for cooperation can be a useful tool for prosecutors in pursuing the more powerful criminals. For example, a plea bargain offered to a member of a drug gang can help bring down the kingpin. Can those arguing in favor of abolishing plea bargains offer a compensating approach in this case? That's the first one.
I'm sorry. Can you? Was that a question for us?
Yeah.
Okay.
Can
you repeat that question?
So essentially what they're saying is when it involves several defendants, particularly the example that they use is a drug gang, that you use the lower members, give them a plea deal for the higher members of that gang or that cartel. What's the compensating approach? What's the alternative approach in a case like this where offering a deal is the only way to get them to turn on the larger members of that gang?
Okay, sure. So ultimately, I think that remember that it is the job of the prosecutor to get the evidence and convict them. The prosecutor has the burden of proof to convict, to prove guilt beyond all reasonable doubt. And if you're coercing people in order to give up your rights, then ultimately that is a problem. That is the fault of the prosecutor themselves. They simply need to do a better job getting to the evidence. In fact, I would argue that encouraging people to snitch often has a far worse problem. There's far more harms than good. Alexander, That's a puff. In their article, Snitching, Criminal Informants in the Erosion of the American Justice. Police and prosecutors offering deals to criminal offenders in exchange for information. Although it is nearly invisible to the public, criminal snitching has invaded the American legal system in a risky and sometimes shocking ways. Snitching is a first comprehensive analysis of this powerful and problematic problem, in which informants deal generates unreliable evidence, allows criminals to escape punishment, endanger the innocent, compromises the integrity of police work, and exacerbates tension between the police and poor urban residents. Driven by dozens of real-life stories and debacles, we have to the social destruction that snitching can cause in high-crime African-American neighborhoods. And all of that by delivering to the secret world. Snitching reveals deep and often disturbing truths about how it actually works. So ultimately, I think all of that. So yeah, have a response.
So I'm just going to point out there's really no alternative for addressing white collar or unorganized crime with David's case. Sure, there might be some negatives, but in doing so, he's effectively leaving these people without any recourse to actually address them. He doesn't address the problems with actually getting a hold of this information in the absence of plea bargains, which I feel are pervasive. You really can't address these in any other way.
All right, next question. Taddy Bogle asks, what level of legislature, whether it should be state or federal, would need to pass the relevant legislation to achieve the abolition of plea bargaining? If state level, how could you achieve this across the United States? Good question.
I think we'd be talking about federal.
Federal, okay.
Yeah, I would argue that it would probably be both the federal and the state. The federal prosecution would only apply, I guess, to federal crimes. So I think it would probably have to be both the state and the federal level.
Okay. The next question comes from Stephen Cup of Reason. He says, I do not have a problem with the plea bargaining system for those who are facing long periods of incarceration while waiting for their day in court. As long as the prosecution agrees that the plea is acceptable, then the defendant should have the right to take the plea and resolve the case before trial. But what I think should be abolished is the right to plea bargains once the prosecution and defense process has begun, particularly for defendants who know that the guilty verdict is unavoidable and they are trying to get out of the just punishment as prescribed by the law. They have the right, their rightful day in court, so they should be prepared to face the consequences of the outcome. So would either side like to comment on the idea that once the trial has begun, there should be no option to plea bargain?
I would actually agree with that. Once you actually start the trial, it should be seen to the end.
I largely agree with that. When you're making the choice to go to trial, I think you should be in that choice as long as you make that choice to go to trial. That being said, I mean, I could see some value in being able to plea even past that point, just for the sake of incriminating other people who deserve it. I'm kind of mixed on this one.
Great. Neil K asks, if abolished, should those that used the plea bargains to escape the death penalty have their plea deal revoked? I don't think that's possible, but
I don't think you could revoke a plea deal, and I don't think it's ethical to revoke a plea deal.
Yeah, I'm with you on that.
And just a few comments. Most people accept a plea deal. This is from Grumpy Old Dude. Most people accept a plea deal because they're guilty. Each case is different and should be treated as so. He also says part of the issue with justice reform is we need to stop having different laws state by state. Is that something you would agree with?
Yeah, I would actually agree that having disuniform laws across state levels is actually a pretty serious problem. Having uniform laws that apply throughout the United States, I think, would be highly beneficial, especially in cases such as that involve guns. Um, I think it would be much more beneficial to have gun permits that are valid in all 50 states than in some states versus others. So, and in a sense, I would agree with that.
That's a good point about disproportionality based on where you live, which I think invites its own problems. I do think there's value in testing different ideas of how to change the legal system on a state level as opposed to doing it nationally. That being said, I think making an experiment of any given law change can lead to its own problems.
Right. Though, at the same time, I think OTP lawyer says, OPT lawyer, is you really can't force the states to have the same law, and that is true. That being said, I do think that it would be better even if the states come together and say, okay, we're going to agree that this is going to be our new standard. And in the Supreme Court case that I cited in my opening speech, one of the criteria for proportionality is to look at the same crime and how it's being applied in different jurisdictions.
Cool. The last question is from Professor that I've seen anyway. Guys, if you do have questions, just tag me in. What would happen if you take the plea bargain, but they find someone had committed the crime? Do you have the crime removed from your record? Or if they hadn't commit the crime, I think he means. If you took the plea bargain and you were found innocent, I think there's a whole nother setup for that.
Yeah, that goes back to my contingent. I think it'd probably be easier if you went to trial to get it overturned, and then if you actually pled guilty. I think there's one thing that I wanted to address in the comments. OPT lawyer, what about the defendant's right to waive their constitutional rights? Does that matter at all? And as I mentioned, my affirmative plan that I mentioned that yes, defendants could and should have the right to plead guilty to a crime. That is one thing that I put in my affirmative plan. But I think it is wrong to get the prosecutors to incentivize them into pleading guilty.
Yeah, I think there's a problem with not incentivizing it, but I already made that clear. I would say that when it comes to providing any kind of ability to waive their rights, I think that's fundamental. I think they have to have that ability. But I agree with David. I think that exists on both sides. It's just not. There's no incentive to do it on his side.
OPT lawyer actually follows up and says, do we not trust the defendant to waive their own rights?
And yeah, that's what that's part of my affirmative plan is that the defendant, by pleading guilty, inherently gives up their rights to a trial.
I guess what we don't trust is that they're able to independently make that choice, uncoerced, in the presence of a benefit, and that's where one of the main disagreements is here. So whether we trust them to be able to make that independently on the basis that they benefit is really important.
Cool. That's all the questions that I've seen.
Yep.
Right. So we should be going into the 3-minute closing statement, shouldn't we? And I can't remember who is going first. Is it you, David?
We decided to reverse the order for the last two speeches so that
Okay,
the last word.
Yeah, by the way, in my last speech, Dr. Pollock, before you start, you mind if I make one more comment about the jailhouse and informants and stitches and stuff like that you brought up in your opening speech?
You're welcome to respond to anything.
Okay, I'm welcome to respond to anything. All right, sure.
As long as it's not a new argument, you're welcome to respond to everything.
Yeah, I'm just going to bring up a couple of statistics about the jailhouse niches and the solving crime that you presented. I don't know if it would, I don't know if it would qualify as new evidence or new arguments or anything like that. But feel free to chastise me if you feel that it is new evidence and new arguments.
Well, you can call a point of order and say that it is new evidence, and we can move on.
Yeah. If you think it's new evidence, I'll give you an opportunity to respond to that if you want. Would that be fair?
Okay.
Okay, let's hear it.
So, is Mark going first then?
Yeah.
Yeah, Mark's going first.
And I will, as soon as you say your first word, I will hit the stop clock. 3 minutes, and whenever you're ready.
Fundamentally, this is an issue of choice. And a lot of this debate comes down to the question of whether, because you are receiving benefits, you can adequately make this choice. I would say that it is perfectly possible to see a benefit and make a choice based on that benefit without feeling coerced into it. The fact that prosecution or defense may feel pressured to reach a deal does not mean that the process is an involuntary one. External circumstances bear down on negotiations all the time. The state of the battlefield influences the negotiations on a treaty. The state of parties' respective finances affects the negotiations on a commercial contract. The parties' resources pressure negotiators in a civil case to settle. The severity of the crime and the strength of the evidence affects plea bargaining. Such entirely ordinary pressures are not tantamount to coercion. That one may have an incentive to come to terms does not mean that one is forced to do so. But even if we concede the idea that some coercion is happening, I would say it is better to give them the opportunity to decide whether that coercion is something that they care about, whether they're willing to accept it or not. Because really what the difference here is are you going to just wait for your day in court where you're going to have a public defender who's not going to be able to defend you very well against a prosecutor who just wants to get through the case as fast as possible so that they can move on to the next one, and likely has far more resources than your public defender? I would say that it's better to give them the option to see both circumstances and make a choice. In the absence of that, they are not autonomous. They cannot make these choices. And really, the only other major thing here is whether you think that everything will just be solved if we give it enough time. If we just push the system to do something, everything will be addressed. But the reality is that they're not going to be addressed. The system is already overtaxed and no one is doing anything about it. This response will only make that system far more overtaxed. That's going to hurt the poor. That's going to hurt justice in general. That's going to make it impossible to get to white-collar crime and criminal enterprises. We need plea bargaining. Without it, we lose an essential tool to make sure that justice is served and to give people their autonomy to decide whether they want to go to trial.
5 seconds left. Okay, that's extremely well timed again. Really impressed. We've not gone any more than 10 seconds away from our time limit today. I think that's amazing. Okay, so do we switch over to David now?
Mm-hmm.
And again, David, when you say your first word, I will just hit start.
The resolution in this debate asks whether or not the United States has a moral obligation to abolish plea bargaining. And I can say that the answer to that question is yes. But first, I wanted to address the issue of the false testimony, the people pleading, the snitches, so to speak. And if Dr. Pollack feels that this is new evidence, I will give him some time to address this. Ultimately, the biggest problem here is that it is often tainted with false testimony and false evidence. There are many incentives for snitches to give false testimony, such as the fact that they have no option for freedom because of a lengthy sentence. And this goes back to his criteria of autonomy. When you're pretty much being forced to make a false testimony plea, guilty to a crime you know you didn't commit, this reduces the autonomy of the defendant and coerces them into pleading guilty. So, in other words, I affirm this resolution because the harms of plea bargaining far outweigh whatever benefits it might give. With that, I rest my case.
Okay, God, you had. There we go. Was that new evidence? You think, Mark? Do you want to respond to that? What's your thoughts?
I mean, there's he kind of made this point earlier. He just provided evidence to support it. I'd still say that my responses to it are still valid.
Okie dokie. So that brings us to the end. What do we do now?
Well, we are joined by the amazing OPT lawyer. So I'm going to bring OPT. Hello.
Hello.
Excuse me. Hi, everyone.
Yeah. Hey.
I apologize for that slip up on prosecutors. That was my bad.
It's okay. When you said it, I just went crazy because it's like, whoa.
No, you are right. You are right. I made a brutal error, and I immediately did what I could to.
I do appreciate that. Yeah, I'm gonna try to give some points because my energy levels are dropping significantly. But
Yep. Hey, Katz, what did you think of the overall debates? Hopefully you enjoyed it.
Yeah, no, I enjoyed it. For me, like I said before we started, it's something that I know so little about. Politics or legal system in America is something I know nothing about. And I'll be honest, I've never even thought about plea bargaining and whether it's right or wrong. So as the debate went, in my own mind, I was kind of going one way and then the next. And it'd probably take me a while to absorb it all and think about it before I can form an opinion. But it was that's what I like about this channel. It's better than dealing with flat Earth or whatever. It always brings something new and interesting and a bit more meaty to think about. So, guys, thank you for both the way you prepared yourselves, the amount of information you brought, the way you presented yourselves. Thank you for all that.
Yeah, I thought it was great actually listening to the back and forth and whatnot. Like both of you had, you're good. Both of you had great points. Both of you explained them very well. So I don't want to act like any of this is personal at all. You guys did a very good job, and I appreciate the discussion.
Well,
I never take criticism personally.
Yeah.
OPT. I'm going. What I wanted to do, because I know you were taking notes throughout the debate, and what I wanted to do, because I don't want to be pushing you if you're not feeling up to it. So what I'll ask you to do is give your full opinion, and then we can have an open discussion with the lads, if that's okay.
Right. Well, I guess I should first state my own position is that I believe plea bargains are an integral part of the system that is useful in many, many areas. David, I also agree with a lot of your points, though, in that drug crimes are overcharged completely. Like in Ohio, for instance, almost every single drug charge carried with it a mandatory license suspension, which every one of us on the defense board thought was dumb. But they finally got rid of that. I think Ohio realized that we want to put, if we're going to put people on probation, we want them to get jobs, and if we're going to suspend their license, it's harder for them to get a job.
Yep.
You guys ended up covering a lot of the points I was going to make near the end of this, but I think my biggest issue is simply the waiving. The defendant has the right to waive their rights, their constitutional rights, and here's the thing. In the ideal world, and I only say this because right now I work for a court, I work for a judge. So like I get to see her work, and she does this better than a lot of other people do. The judge is supposed to make sure that you are entering your plea bargain intelligently, voluntarily, and knowing all of the potential penalties of what you're facing. That's supposed to happen. Now, whether or not it does, I can't vouch for any other court, obviously, just the ones I've been in. But when you waive your constitutional rights, and it's not just the right to trial, it's the right to call witnesses, it's the right, to have the state prove its case beyond a reasonable doubt, it's the right to not testify, it's the right to not have the prosecutor able to point out that you didn't testify. It's also your right to testify. You have the right to do that too. Good old Fifth Amendment. I love it. Don't leave home without it. It's a great amendment. But like, my issue is that as much as, yes, there are a lot of people who are uneducated about the system, there are a lot more people who are educated than you might think. Again, in my experience, because I used to take appointments for indigent defendants. I'd say about 85 to 90% of my cases were appointed. I was not part of the public defender's office. In my county, about like 30 or 33% of felony cases are appointed at the public defender's office. The rest are actually appointed to the private bar. So you're getting private attorneys a lot of the time when you get appointed. And I think part of that was to not overtax the public defender's office that doesn't have a lot of attorneys in the first place.
Good to know.
Yeah, and this is my county, and most of the counties in the state of Ohio, from my experience. Again, I haven't gone to all 88 counties in Ohio, so I can't tell you that's true or not. But the counties that I've practiced in have pretty much the same thing. Just getting to the waiving part, like, again, the courts are supposed to make sure that you're waiving things properly. And yes, we put in plea agreements, and these are in writing, and they have to be signed by the defendant themselves, along with the defense attorney, the prosecutor, and the judge. They put right on there, like, this is what the state is agreeing to do because you're pleading. And at any point, you can say no. And we can just be like, okay, we'll go back into pretrial status and we'll figure out what you want to do. You can go to trial. Speaking of trial, the trial tax that you mentioned before, in Ohio, and again, I can't vouch for any other state, we literally have case law that says that that's not allowed. And you are not allowed to give a trial tax. And if something comes out that is a trial tax, that case gets reversed. Because we don't like trial taxes. Now, that doesn't mean you're not necessarily going to get more if you go to a trial, necessarily. I've seen cases that went to trial, the judge is given the exact same thing they would have given on a plea. I've seen cases where you get more only because, look, the evidence against you was overwhelming in the first place. There was no reason, like, you went to trial because you just didn't want to plea. Get that. You're right. But you clearly don't have any remorse for what happened. Like what you did to the victim, for instance. Mm-hmm. And there's like complete overwhelming evidence to the point you didn't even put a case on. Now, again, it's the prosecutor's job to prove everything beyond a reasonable doubt. Defense doesn't have to put a case on. And sorry if I'm rambling too, because
it's fine.
Got medication starting to get to me.
That's good stuff. I appreciate it.
What I'll do is to give you a little bit of a break and organize your thoughts. Bring Tusk in. Tusk, how are you?
I'm good, thank you.
What is your opinion on this?
Oh, I have many opinions on this. Do you want my personal opinion or my legal opinion?
I love how those are completely different.
Yeah, I only get paid for one.
Let's start with your legal opinion.
My legal opinion, okay. Plea bargains are an absolutely necessary part of the system. Without them, the justice system would grind to a halt absolutely within weeks. I just want to address a few things in the chat. I'm not going to pull names out or anything. A lot of people don't seem to understand how the justice system works and seem to think it's completely corrupt and biased against the accused. And, all lawyers are crooks and so on. And, that's not how it works. And the two, David and Marc, presented their case very well. But I feel they got sidetracked into irrelevancies. Plea bargaining is a tool used between defence lawyers and prosecution lawyers. It doesn't really have anything to do with snitches and social conditions and bail conditions and everything. That's obviously as part of the entire system, but it's not really a part of the plea bargaining system. That's a administrative tool more than anything. But that's a minor point, but it all comes together. But if you take it like a paradigm, like I say, a young man from a disadvantaged background is faced with the choice of pleading to a lesser charge or spending 2 years in jail to await trial, then of course that happens, and it happens far too often. But you can't use that as your case law because it's a paradigm and it doesn't address all the myriad of other situations. Which, if I can ramble for just a moment longer, I was involved in a case a few years ago of fraud. It was a financial case at one of the bigger financial companies, private company, but very, very rich, very powerful. And they had been accused of insider dealing and fraud. And they were charged with various offences. But the difficulty the prosecution had was putting together a jury of impartials who had the knowledge of the financial system, or enough knowledge of the financial system, that they would understand the evidence put in front of them. And what was most likely going to happen is this would drag on for 5 years and any trial would collapse simply because it was so complicated. So what eventually happened was 5 of the 6 directors took a plea bargain of a lesser charge and lost their licenses, and they weren't allowed to serve on or be part of a board of directors for 10 years. And the head of the company was, I think he was banned for life, and he was given a £50,000 fine. But without the plea bargain system, they would have gotten away with it. It would have dragged on for years and cost a fortune. So the best outcome in that situation was accept a plea bargain or offer a plea bargain. And they all accepted because they knew that they could still work in the financial sector. But as, sorry, I had my second jab today, I'm a little tired. They could work as consultants rather than board members, so it didn't really affect them. But there was always the outside chance that the prosecution would put a jury together and they would be found guilty and they would be convicted of a much more serious offence.
There's one thing I absolutely can say about the jury trial is that juries are completely random at times.
Yes.
This is why prosecutors and defense attorneys don't want to go to trial a lot, and why a lot of defendants don't want to either. Like, the thing is, like, my case is, I had one case I was about to go to trial on, and at the last second, my client is basically like, you know what, I'm going to plead. It was like, you know, as they were calling the jury up, he decided, you know what, I'm going to plead to this. And the evidence against him from what I had in discovery was pretty, you know, it was pretty damning. But, you know, I was going to try. You know, I had a couple arguments that weren't completely terrible. But, you know, I was going to try to bring some stuff out on cross. I was as prepped as I could be as a young attorney. But he decided at the last second. And it's one of those things when defendants see the whites, what we say, the whites of the jury's eyes, that they're like, holy crap, this is real. And you know what? Never mind. I want to plea.
I saw that. And I do want to address a couple of things in the sidebar chat. Some people are wondering why we're actually debating this topic. So speechanddebate.org, which is a national debate tournament thing for mostly for high schoolers, and there's some college level debates. This was actually one of their topics from January and February 2018. If you're not familiar with the Lincoln Douglas debate style, this debate kind of was loosely, the format of this debate was kind of loosely based on the Lincoln Douglas format. So we decided to do this topic. It was a national topic from 2018, and thought, you know, this would be a good topic to actually discuss because there's a lot of ways you can go with this.
Yeah, there's no right answer to this topic. Let's be honest here.
I also want to make the point that the whole point of a debating channel is to debate all manner of things. And plea bargaining is something that is up there, that is in our society, that is really being discussed and debated at the moment. So, especially with some of the recent trials and the upcoming trials. So it is something that a lot of people don't know the ins and outs of. So having a debate where you get proper information and then you get to make up your own mind, that's part of the debating channel as well. So I do want to make it clear that we're not shy on what kind of things that we're willing to debate here.
So here's one thing that I didn't hear come up in. Oh, sorry, go ahead, Dave.
Okay, sure. So this is a great comment from Chris, and this is kind of the point that I was trying to bring across. So from what I've heard, it's a tool that allows the innocent to be found guilty and the guilty to not face justice for the crimes they committed, and the defense is basically the system would collapse. So yeah, that is a pretty good summary of the debate and pretty much a good summary of what I was arguing.
I don't think any criminal defensive lawyer will tell you the system's perfect. It's not. Nothing's perfect. Everything is susceptible to human error and whatnot. The problem becomes when we, as a defense attorney, are handed, discovery with police reports, video, whatnot, and we're left looking at this being like, if we go to trial, we are going to lose. Like, that's just the short in front of it. We have way too much evidence against you. And as I said, for the most part, my clients never said they didn't do the thing. A lot of times my plea bargains were to actually get down to what my defendant actually did. Because when the prosecutor goes to the grand jury, all they have for the most part is like the testimony of the lead investigator. So that's why you get a lot of crimes that are charged higher than what it ends up being, because the investigations normally don't just stop at the grand jury. And the prosecutor will finally get all the police reports. They'll look over everything. They'll interview their witnesses and realize, I don't think he actually did this, but he did something lesser, what we normally call like a lesser included. A lot of plea bargains end up basically having the defendant plead to what they actually did instead of what they're charged with.
Yeah, you see that a lot, especially in the British system, where the prosecution will look at the absolute worst case scenario for the defendant and they'll put that onto the charge sheet, but 4 or 5 charges down will be what they actually did. So they look at that charge sheet and go, I'm looking at 10 years here. So, okay, I'll admit that I actually did that.
Yeah,
because I'm terrified of being tried for this more serious charge.
Yeah, Paul Dreyer, thank you so much. Very good debate. Well done by Mark David. Thank you so much. And yeah, I really hope everyone enjoyed this debate. It's nice to finally debate something other than young Earth creationism, which is a lot of the stuff that I debate.
Is that not dead yet?
You would wish.
Young Earth creationism.
I really wish.
Yeah, young Earth creationism and flat Earth are two debates that I'm just grown so tired of, and I'm glad that this is actually a decent debatable topic, and I think that this debate went really well for both of us.
Agree. David, do you have time for one more point? I actually want to get your thoughts on this.
Yeah, go ahead.
Sex cases.
Yeah, that's one of the things that I kind of wish I would have harped on a little bit more in the cross-examination round, and kind of wish I could have harped on in my
Let me pose something that doesn't happen often, but does actually happen. We're talking about a sex case, again, like a sexual assault against a minor, which in my opinion is one of the worst crimes that you can do.
Oh, absolutely.
But a lot of times prosecutors' offices will plea bargain with the defendant because they don't want to cause the minor victim the trauma of actually testifying, because in order to testify, they have to testify not only just in front of the defendant, but there's 12 jurors in the box, there's multiple attorneys in the courtroom, there's people watching in the courtroom, and then there's a judge who should have been interviewed by beforehand and whatnot. But I know our prosecutors' offices have studies that show that this can be very traumatic to the child. A lot of times they try to get a plea on some sexual assault charge, so that one, the person is still going to be registered as a sex offender. And in Ohio, we have a tiered system, and you can still get like a the top tier, which means you're going to be registering for life, without forcing the child. And I'm talking about like 10 or less. I'm not talking about like 13, 15-year-olds who are able to fend for themselves or kind of a thing. But when you're talking about a young child, forcing them to testify, because they will have to testify.
Right,
Like, there's no way they can get around that. A lot of times your plea bargainings are going to be based around that. Now, I'm not saying childs have never testified before. In fact, sometimes, you get like even a 7 or 8-year-old that are like ready to tell their story and they don't care and they're freaking amazing.
Right. And
can I just come in on that, because
Sure.
I do have direct experience in exactly what you've just been talking about. It's not just children that are traumatized. As a woman, when you go into court, there are a lot of hurdles that you have to jump, and there is a lot of to get to that point. There's a lot of trauma involved, not just going to the police, but actually getting to that date in court. If you get to that date in court, because remember, well, I can only speak for myself. Over here, it depends on the DPP, the Department of Public Prosecutions, of whether or not you're even going to get to trial, and whether your case is even going to be taken up.
Yeah.
And that in itself can be traumatic, that whole experience. So it's not just for young children.
Right.
It's whenever you're a victim of a serious crime, to go through all of that and then to actually have to sit in the same room as the person who caused you harm, and recount and recall and be cross-examined. It is not an easy thing. It is not. It's re-traumatizing fourfold.
And please don't think I was minimizing the effect it had on adults too. But yeah, I wanted to focus on minors because it's
in the UK system, if you are a minor and you're a victim of a crime, there is provision made that you'll be not interviewed. Well, I suppose you will be interviewed in the first instance, but you'll be put on a witness stand remotely. You won't be in the courtroom. You won't be around any of the jurors, the judge, prosecutor, or so on. You'll be in a small room with an advocate, and you'll give your evidence to them via a remote link. So there are moves, but at the moment, it is really only children and victims of serious violent sexual assault that are afforded that. So, but again, it's all down to time, money, and resources, none of which the court have in abundance, unfortunately, due to. Okay, go on.
No, go ahead. Finish up.
I'm talking to your experience, so I'll stay out of this for now.
Hello.
I wanted to change pace there a little bit, and bring on Grumpy Old Dude. But before you do, David.
Yeah, real quick, I do want to address what OPT lawyer said. Yeah, that is a really good point about requiring them to go to trial and actually testify. And yeah, it is very traumatizing and very hard to do. And I think the prosecution should give far more resources to help the victim. What I'm seeing a lot of times is that they really don't help the victim. They don't even try to include them in their plea bargaining. I think that at the very least, if you want to try and get someone to plead guilty in the sex crime charge and give them a plea deal, you should at least get the victim's input before you go to them, I think.
Well, Dave, let me tell you some good news then. In Ohio, we actually passed a constitutional amendment that requires the victim to be able to be heard at every stage of the proceeding.
Yeah, I really wish all states had that. I don't know if we have that in Maryland, but if I ever
look up Marcy's Law, and I believe that is starting to become a thing in a lot of states.
Yeah, if I end up becoming a delegate, that's one of the first things that I'll try and do.
Good luck with that. Seriously.
Yeah, but I think that this was a great debate, and I really enjoyed it a lot.
Well, I wanted to, before you jumped out, I wanted to get Grumpy Old Dude on, get his opinion, because you are an ex-convict and you have a lot to say about this.
I've actually been convicted in 2 states, New Jersey and Pennsylvania. and I've successfully overturned convictions in both of those states.
Nice.
Congrats.
Congrats, man. Seriously.
Well, thank you. Now, there are cases that I did take a plea bargain on because I was guilty and I owned it. And what am I going to do? Am I going to go to trial and lose and take a 20-year sentence, or am I going to fess up and be like, all right, you got me, I did it, and take 5 years and make it easy on everybody, including myself? So, yeah, I mean, I'm going to take the plea bargain. I did it. I know I did it. Why am I going to waste everybody's time and money?
Right now, since Dr. Pollock, I do have a question for you, because this was something that Dr. Pollock brought up. If you didn't have that plea bargain, would you have just pled guilty to get it done and over with, or would you try to go into trial?
Well, if I didn't have a chance at a plea bargain, what other choice am I going to have but to go to trial?
Right.
Exactly.
If just as a hypothetical, I don't know your situation at the time. If you were on remand, I don't know if you call it remand in the US, if you're being held in a jail, and you were offered a plea bargain, would you take it to get out of that situation into a real proper prison where you had like your own cell rather than a dormitory? Or if you were on bail, would you have accepted the plea bargain where you were still free?
I've actually known people who they told them, hey, listen, we're going to drop all the felonies. We'll give you this misdemeanor and we'll let you go right from court tomorrow if you sign this paperwork. And I've seen people do that. Like, all right, cool, let's get it over with. And they go ahead and sign the plea bargain just to be done and over with.
Yeah.
Right. So, I mean, and I'm not asking about you personally, but if it was a situation where you're being charged with a serious crime, but you'd made bail, and you knew if you went to trial you were going to lose, but you were still free, and you had maybe 2 years until your case went to trial, would you have taken the plea?
Yeah, I'm kind of one of those. I don't back down. If I know I'm not guilty, even if I think I'm going to lose this case, but I know I'm not guilty, I'm not taking the plea bargain.
Right, okay.
Mm-hmm.
I'm one of those two.
Yep.
Yeah, I think I would at least try and fight back. Now, I do actually have a question from the lawyers in the room.
Sure.
If you accept a plea bargain and it's later found that you're not guilty, how is that? How would a defendant go about trying to get that conviction overturned? Is it even possible?
So, at least on the part of in Ohio, and again, this is Ohio, I can't vouch for anything else. There is a mechanism to file a motion to vacate your plea, and it would be based on ineffective assistance of counsel, because if information came up that you're not guilty, that means your lawyer probably didn't investigate as well as they should have. Now, I can't tell you it works all the time because there's standards and whatnot, but it does happen. And there are mechanisms for you to have your plea vacated, and then when you come back with this new evidence, the prosecutor's hopefully going to be like, yeah, we can't prove the case anymore. We're just done.
Right. Now, I've been involved. One of the things that I think, maybe you can go first, and then I'll go.
Well, that actually does apply to me. I had a burglary case. I took it to trial, got found guilty at trial, and they did give me probation because it was my very first ever adult conviction. And they sentenced me to 3 years probation and a bunch of fines and everything else. 4 or 5 months after my conviction, the person who actually did it fessed up to the case. And they got in touch with me, told me I needed to appear in court. They vacated my sentence and erased everything off of my record. I didn't have to file anything.
Oh, nice.
And I did get the money back that I had already paid into the fines.
Wow, that's awesome.
Good,
Congrats on that.
That is awesome. Seriously.
Seriously.
Yeah, but yeah, I really enjoyed this topic and this debate. I'll take from personal
the American lawyers.
one of the biggest one of the biggest
Sorry,
problems
just-
that I see
sorry,
is
just-
that there is so little time. Usually, a lot of defendants and prosecutors have less than an hour to prepare for the case. Back in 2018, when I went to trial, um, I was a plaintiff in a criminal case. I was bringing charges against someone else. We had less than an hour to prepare, less than maybe 30 minutes to actually prepare with the prosecutor. Ultimately, the defendant did a stat deal, and I got the money. I got compensated for it, and we just accepted stat, and I got the full money.
See, that's unfortunate because at least in my experience, there's arraignment, pre-trial, and trial.
Yeah.
So
Yeah.
what you went through is actually really unfortunate.
Yeah, unfortunately, since it was such a low-level crime, I actually had to do the prosecution pretty much myself. I had to prove the charges. I had to go down to court and file paperwork and went through that whole ordeal.
Jeez, that's such a weird. That is such a weird thing to me because in my state, a civilian can bring like a thing to the prosecutor to be like, hey, I want this prosecuted, and the prosecutor gets to choose and whatnot. But I've not actually seen a state where a person can literally bring like their own criminal charges against someone. That's interesting.
Yeah, in my state, I could go down and file charges against someone, and it'll be up. Of course, the prosecution has to do their job, and the prosecutor would say, "We really don't have enough evidence to try this." But yeah, it's really interesting.
I noticed that we are joined by our final guest. Nate the lawyer is finally here.
Hey, what's up? What's up?
Unfortunately, I do have to get going. So
yeah,
thank you for having me on, and I'll see you guys all later.
I can stay on
Thank
phone.
OPT, would you like to weigh in on the conversation about your experience with plea bargaining and where you stand on the issue?
I think you mean Nate.
Nate.
Oh, Nate. OPT, it's gone. My brain is
Me and OPT look alike. We look alike.
It's the hair.
It's the hair.
It's definitely the hair.
First, I want to say to both the people who were both the gentlemen who were making the arguments. They were fantastic arguments. These were definitely fantastic arguments. I've been in law enforcement for I was in law enforcement for about 15 years, and plea bargaining is so essential to the practice of criminal law. I think most people don't understand that without plea bargains, our criminal justice system could not operate. It absolutely could not operate. It can't operate for a couple of reasons. For instance, when I was an assistant district attorney, my caseload at any given time was about 75 to 80 cases. 90 to 95% of those cases were pleaded out, and they were pleaded out because they were obvious pleads, right? You know, did you steal something? Did you use some weed? Did you do so forth? And if I had to take all 95 of those cases to trial, there's not enough judges. Don't forget, we got to get juries for each one of those. It just becomes a mess. So it's so integral to the part. So I understand philosophically, you know, there are some errors because our system isn't perfect, and I think you can't throw out the good for perfection. But I do understand there are a lot of limitations in the plea bargain process, because yes, I'm going to say when I was in law enforcement, I did get a couple of times people to confess the things that they didn't do because of the pressure. When I was an ADA, I know that I'm assuming that some of those people who were caught on minor crime, who were caught on crimes may have been pressured to pleading to things that generally they were unlikely to have done. But sometimes it's not about it's about the evidence. And one thing I want to make it very clear is that the ethical constraints for a prosecutor are different than for just a regular lawyer. If you were never a prosecutor, most people don't realize this. But as a prosecutor, our oath is not to get convictions. Our oath is for justice. So, and that's the first thing they tell you. We are not here for you to get convictions. Convictions are the last thing you're supposed to do. You're supposed to look at the evidence, evaluate the strength of the case. And if you think a conviction would further justice, then you seek that conviction. But if you're just there to seek convictions to build a reputation or something like that, you will find yourself on the bad end of an ethics complaint. So our system holds even the state prosecutors to that higher level to that higher ethical level because they understand the state has this huge amount of power and that these prosecutors need to seek justice and not convictions. So with that said, I do understand, like, what is it, 95, 97% of all cases plead out. But I think that's, our system could not work unless that happened.
Yeah. So is it more a case of then it prevents an overloading of the system? Is that what you're sort of saying? It's like a capacity issue.
Yes. Well, look what's going on in California right now. In Los Angeles County, more specifically, they have a new DA who is extremely left wing, and he's saying that he won't prosecute most of the crimes that are being arrested by the police. Now, the police obviously arrest for both petty crimes and more intense crimes. So what happens is that since the DA has come forward and said, well, we're not prosecuting for all these petty crimes, now all those DAs can't get plea bargains, right? Because all these guys are saying, well, the DA is not going to prosecute us. So they now have something which would take, let's say, a stolen backpack, something that'll take maybe like a month or 2 months or even maybe 3 months to end, is now taking 3 years. So now you've extended the system for every individual person. Now just imagine, that's 3 years worth of court dates, 3 years of not knowing. And because one of the piece I think is being missed here is that the laws are actually written to foster plea bargaining. So for instance, like you'll hear something like in the Lori Loughlin case. That's the person for the college admission scandal. The charges, when she was charged, she could have gotten, if she was getting the max, she could have gotten like 40 years in prison. But she plea bargained for 3 months. And that's because the laws are written to induce people to plead to lesser charges, right? I can charge you with something that's going to get you 10 years, but let's plead out to 6 months, right? Because it's actually kind of built in the system to force people to plead and for the system to be more efficient. And like I said, think about this. You're talking about taking 3 to 5% of cases that go to trial and expanding that to 95% of the cases that don't go to trial. And also, too, one last fact I do want to say about plea bargaining and going to trial. In Bronx County, for instance, in New York City, if they have like a 90% conviction rate, but that's adding plea bargains. But if you remove plea bargains from that occasion, when people go to trial, it's actually 50-50. So you have a 50-50 shot if you go to trial, but going to trial has its own risk and reward. So,
and I stick by my claim earlier. Most people that take a plea bargain take the plea bargain because they know they're guilty. It's that simple.
Yeah. In the UK system, we have there is an incentive to plead guilty before trial, but it's only a 20% reduction in any fine or prison time you would do. So it's not a huge incentive. It's not like you're looking at 20 years, you can plead down to 6 months and be out in 3. We don't do that here. But there's something I want to bring up. I was trying to bring it up earlier, but the conversation moved on, and Nate touched on it there about what a prosecutor's job is. I saw a lot in the chat saying that plea bargains are coercion and prosecutors get paid extra and so on. Prosecution is not vindictive. They're not offering a low-level operative in like a crime syndicate a low reduced sentence to claw past you to get to the next guy. It's because you have information they need. That's all it is. It's not a vindictive thing. If you, Nate will know this as well, if you say aye in court or look like you're being vindictive or giving your own opinion, you're finished. You're done.
Oh yeah. It's that. But people think that prosecutors are just out there to send people to jail, and that's honestly not true. I'm one of the cases that actually got me in trouble when I was in the prosecutor's office. Me and my boss actually got we had an all-out fight about this case. It was a case in which there was someone who was soliciting donations for like a police union, and what happens is if you come to New York City and you solicit for police donations, we know it's generally fraud, right? And the reason why is because in New York City, the police union here is so big that they self-fund. So they don't look for outside donations. They just self-fund. But when you go upstate New York, those police unions those police departments are so small that they kind of come together and hire an outside agency to fundraise on their behalf. So when this person came to the city to fundraise on behalf of police unions, the misunderstanding was that this person was a fraudster and this. So this person had been arrested, charged and everything. So when it came to my desk, I looked it up. I went and looked it up, called the company, did all this background, and said, well, hey, this person is 100% legitimate. But the only piece of it is that they had a civil agreement between this union and the police union in New York that they wouldn't try to raise funds in New York. So then it was like, oh, well, she knew that they weren't supposed to raise funds. So we had an argument. And then at the end of the day, my boss's boss made the call. And my boss's boss said, we're not going to prosecute this woman because it would not serve as a just result. This is not justice, because this was not someone who came down to try to steal money, even if she did do what she wanted to do. She was just raising money for the police union. So, so this would not serve justice. And that's what it's really about. And you have those type of conversations. And sometimes you do have to let bad people go, like with Bill Cosby. Sometimes you do have to let people go who are guilty because justice demands it. And if the one thing that I can get over to everybody sitting here is that if a prosecutor's out there not seeking justice, but seeking convictions, that person is probably going to lose their law license, because that's the one thing universally in America that you're not supposed to do if you're a state's attorney.
Yeah, and
like touch on the Bill Cosby thing there. Bill Cosby hasn't been released from prison because he's been found not guilty. He's been released on a technicality.
Yeah.
right.
Yeah.
And,
So we can still say he's guilty because he's still been found guilty.
yeah, Wade Watts.
Well, just to make sure, Bill
Yeah,
Cosby
real quick,
has not been found guilty of anything. Bill Cosby actually, at this point, is not guilty of any crime.
Okay.
As a technical matter.
Okay. But yeah, okay.
Wade Watts, really good super chat there. I said this in the previous sales stream: who would plead to a crime to avoid the death sentence? That's where it goes wrong, and that's where innocent people get convicted. Exactly the point that I was trying to make. And that was one of the lines of evidence that I pointed out, that people have falsely confessed to a crime in order to avoid the death penalty in other serious cases. Now, for the people in here, just out of curiosity, do you guys find that plea bargaining is coercive in any way?
No, not outside.
I don't. I don't. I don't feel that any time I was ever offered a plea bargain that it was any kind of coercion. It, simply, like I stated earlier, when I knew I wasn't guilty, it was like, I'm not taking your plea bargain. We're going to go to trial. You're going to have to, you're going to have to convict me. I'm not going to plead guilty to something I didn't do. When I was guilty, it was like, okay, thank you. I'll take less time because I know I did it, and I appreciate it. Thanks.
In most cases, like Grumpy Old Dude says, you'll take the reduced charge because you're guilty and it's too dangerous to go to trial. So if they say, look, we know you stole this, but we're going to drop the fraud charges if you accept the theft charge, you're going to get a $500 fine for the theft, but you're looking at 6 months for the fraud.
Yeah.
Fraud's difficult to prove. Theft's relatively simple. So you plead guilty, and it saves everybody's time, and you're rewarded by the court for saving everybody time and money by a reduced sentence. It's not coercion because it's not really carrot and stick because they hold both.
Well, it can be coercive in the sense of if you're trying to move up the chain, if you're trying to move up the ladder,
well,
right? Like sometimes, because sometimes, go ahead.
Honestly, my biggest problem is how disproportionate the sentences are between those who go to trial and those who aren't going to trial. Having such disparities, I don't think is the right way of doing it.
Well, that's because, even when you're in law enforcement and when you're as a prosecutor, what they teach you to do is to I don't want to call it overcharging, but to charge to the fullest extent of the law. And there was a case I was involved in when I first started, and there was a gentleman who had taken a woman's child. Like, he wasn't watching the child, but I think he had taken this child from a park, and he had taken a child, but he knew the family, he knew the child. So he took him from the park, and they went to an apartment, and nobody knew what they did inside the apartment. But then eventually they found the kid, and they arrested the guy. Right now, initially they charged this guy with misdemeanor, with a misdemeanor, what's called custodial interference, that he interfered with the custody of the parents with the child. It's a misdemeanor. It was like a nothing thing. If this guy's lawyer was smart, he would have said he was guilty, and that would have been it. He would have said, I'm guilty of that, and took that misdemeanor charge, and it would have been done, because it was a misdemeanor charge. But he did. He said he was not guilty. That allowed the prosecutors to investigate, and then when they investigated, they found that there was some criminal sexual assault that happened. So if that person would have taken a plea to that lesser charge, that misdemeanor, then the prosecutors would not have been able to charge him with the criminal sexual assault of a child. So that's why generally prosecutors say, well, what's the most we can charge someone with? What's the most we can charge someone with at this particular time? Because you don't want to have that situation where you've charged someone with such a small with a misdemeanor, and then find out later that they've committed these high level misdemeanors.
All right.
Hey,
I really appreciate the insights, guys, but I have to hop off.
Yep, same here. It's good to see everybody except Katz. He's a weirdo.
Thanks for hosting this. I really enjoyed doing it, and especially thank you to David.
Oh yeah, definitely. I really enjoyed this, and it's a risk. I really hope I really hope you allow us to come back on again.
Oh, you're more than welcome. All more than welcome. Just before you dive off, I did promise I'd read this out earlier on. Traveller X, before the debate started, did drop a super chat. Thank you so much. Just to say, it's such a complex issue, and he's genuinely interested in both sides of tonight's debate. And I think you would both have done him proud with that. I think because you were so well prepared, so articulate, and you certainly taught me a lot. Not that it takes much to teach me anything, but you did well there. Thank you.
Yeah, I thought this was a very solid debate, and I think this is one of my better debate performances. So definitely thank you everyone for coming out, and thank you everyone.
We'll definitely have you back on. We'll definitely have you back on another subject for sure.
We'll
definitely be back. Dr. Pollock and I are good friends, and we enjoy debating each other.
Yep.
Cool.
That's amazing. I want to say one last thing to the chat. You guys got to subscribe. You guys got to hit the like button. Come on, people. This is, if you guys sat here and enjoyed this whole thing, give it like, share, subscribe, do all that great YouTube stuff, because that's the way we pay the bills, and that's the way we can continue to do this. So
absolutely. And everyone that was involved in the live stream, we will be putting the links to their channels, particularly Tusk's, because we want them to do more live streams. No, I'm joking. I'm joking, Tusk. Don't hate me.
You'll pay for it tomorrow.
Anyway, thank you guys so much for coming out. Thank you guys so much for this time really flew by.
Yes.
Cheers, David. See you again, definitely, mate.
Take care, guys.
Right.
Okay.
We're left with the lawyers. No, seriously, guys, thank you for jumping on, because it was an important discussion, and it is important to get the as well as just having the debate, but actually getting people who are qualified and experienced in that field to get your take on it is invaluable.
And I do have one question for Nate. Just something you said before, right? And this is going to sound like a really ignorant question, because I am ignorant of the topic, all right? But you were saying before, obviously, the prosecutors are chasing justice and they're not chasing the convictions. When I watch like the legal courtroom drama films and stuff like that, and you get the high flying lawyer who's got a really high conviction rate and is going up, like, is there such a thing as that, where if you do have that high conviction rate, then you're more employable, or is that just all a Hollywood myth then?
Well, again, that may be unique to the lawyer. When I was at the DA's office, nobody ever talked about conviction rates. What people did, because it was really about the strength of your case. Like sometimes, because when you get a case, right, it's you never know. It's all right. Let me step back. The way we were assigned cases was extremely random. So if I was working, like sometimes I'd be working on a weekend, and the next thing I know, a case would come in about child sex assault or something, and that would be my case, right? So I didn't have a choice of what cases come in. So if my job depended on conviction rates, then it's giving me an unethical incentive to get convictions, right? Because now all those cases, if I'm just trying to get convictions on cases, I'm not really doing my due diligence and trying to figure out if there's justice involved in these cases. So where I worked, it was never about, I never heard conviction rate, but on the back end of it, yes, obviously, if you're a prosecutor who people think that you're competent, that you get convictions, that you do so forth and so forth, yes, that it's obviously a status symbol. We had the top grade prosecutors who convicted everybody, but even those prosecutors, when they had cases that they felt were, they had to dismiss because of justice, they did. And nobody saw it as lowering your conviction rate or they lost the case. Because for us, it's not the winning and losing it's not about winning and losing. The win is justice, right? The loss is injustice. So it's not the case itself. If the jury comes back and says this person's not guilty, that is justice. You know what I mean? I don't know if I can explain that any better than that.
Yeah, it makes perfect sense. Yeah.
It's like I was saying earlier on, the people in the side chats experience of the justice system seems to be from watching movies where it's the high flying lawyer, they bring him in because he's this great prosecutor. That's not how it works. You don't get to choose your cases. And maybe if there's someone who is expert in a particular matter of law, because there are so many different aspects and divisions of law, it's so dull. That, say, someone who's very good at prosecuting, say, financial crimes, then they'll put him on if they have him or her in the film. But it's usually, it's not like it is in the movies where you're going through depositions and so on. It's really tedious, boring, reading over and over his financial statements over and over again. And that's what makes you a good lawyer or a good prosecutor, a good defense lawyer, as if you spend the time doing it, not as if you're some hot shot, it doesn't take any crap from anybody and so on. That's just not how it works at all. But of course, there are high-powered private law firms in the cities where they give the image, the Versace suits, the Bentley, you walk into these buildings, there's marble everywhere, and it just says money and power. But at the end of the day, I don't want to use the word lose, but they'll lose as many cases as they win. If you take that as not getting a conviction as a loss, because sometimes it simply doesn't serve the public interest to continue a case and seek conviction. It's justice you're looking at. So as Nate said, it's not about getting a high conviction rate. Are you competent at your job? Even if you do all your due diligence and you still lose for a given value of lose, you're still valued by your company and the system because you did your job.
Yeah. If people are counting wins and losses, like, don't get me wrong, because I don't want to make it seem like after you have your first jury trial, you know what they do? They have like a little celebration for you. Sometimes they'll cut your tie off, if you get your first conviction. So, it is that type of camaraderie. Hey, you did a good thing. But we also have those celebrations when someone, comes and makes that hard choice. Like, I got to let, I know this guy's guilty, but I can't prove it. And I got to let this guy go, and a lot of people, for some reason, they have that Hollywood piece of prosecutors, but I've been in situations too. Like we used to, I did a lot of sex crimes, and we used to get former prostitutes who would get convictions. Like we had one woman who had something like 30 something convictions for prostitution, but she was being sex trafficked. And what happens is the pimp would put her out there. She was an undercover cop, and she would just continually get caught up. And she had 30 convictions for prostitution. So she came to us and showed us that she was being sex trafficked. And we went to the court together and said, this is a miscarriage of justice. We need all 30 of these convictions to be vacated. We want them to be overturned. We went to the judge, we explained it to them, and they did it. It was, so that's, people only see the conviction piece for prosecutors, but they don't see when we go back. And we had like a whole department where I was at of lawyers who just went back and looked at convictions that could have been done incorrectly. So the process was always ongoing. If people, just because you got convicted didn't mean it was over for our office. We then looked at that conviction to see if it was a just conviction. If it wasn't, we would go to the courts and tell them to overturn this conviction. I've been a part of that stuff. So I understand the Hollywood's only going to give you one side of the prosecutor's office, but there's so much more. There's just so much more.
Yeah, and in Scotland, we are the only country, I think, in Europe, maybe even the world, where we have 3 options available to the court. We have guilty, and not proven, which is a lot of lawyers have been trying to get that struck off the statute books for a long, long time, because what it essentially says is not guilty, now don't do it again. because we can't prove it. So rather than being found not guilty, it's not proven, which means you done it. We know you done it. We simply can't prove it. And I don't think that's justice personally. I don't think justice is served by finding someone or finding the case against them not proven. It's either guilty or not guilty. But as Nate says, a guilty verdict isn't necessarily the end, or even a not guilty verdict.
God. Well, it's been an eye opener. This, especially when I mean that's what you've just said there. I had no idea about that sounding. And Nate, when you said before you had like 80 or 90 cases on the go at once, I just can't even comprehend how that works. You know, that's it's incredible.
Well, that's part of the problem. If you work for the public prosecutor or the public defence, like in the UK we have the legal aid system, so everybody is entitled to a defence. You might only see them once a month for half an hour over the space of 2 or 3 years when you're looking at quite serious charges, because they simply don't have time for you because they've got a huge workload. You know, so they have to break it down into, okay, this guy's guilty. There's not much I can do for him. 15 minutes on a Tuesday afternoon. That's all I'm going to spend. This one I'm not so sure about. I'll spend a little bit longer. You know, but you get paid. It's a flat rate. You get paid for it. It's not. You don't get paid hourly. So you have to look at it and say, what's the best use of my time here? So unfortunately, people who are guilty and are clearly guilty don't get the best defence available, simply because unless they're prepared to pay for somebody and put them on a retainer as their particular lawyer, they're going to get 15 minutes once a month until they come to trial. And there's a fairly good chance that the lawyer won't even remember their name when they get into the courtroom. And they'll be constantly looking at their notes to, who is this guy? Who is this guy? You know?
Yeah, no, it's especially when you're dealing with petty crimes and low-level misfelonies. I'm talking about, like, you know, sometimes I'd be in court and I would have something like 200 cases. And I would be standing on those cases. So a file would come up. What happens is, the way the DA's office works here in New York is that we have every day there's like status conferences for each particular case. So we'd have so all the prosecutors would bring down a physical file, and you would have offers, like plea offers, on the top of the file and the person's name. So I would know none of these cases. And in the moment, I'd have to read the case, understand what's going on, offer a plea. Right, the plea that's on the thing, and then if the person rejected or wanted to make a counteroffer, I have to call. Like, it was a whole process, and sometimes we'd have to go to 200 cases in one day, and that's why I keep saying, and most of those cases were plead anyway. That's why I'm saying, just imagine if you had to now go to trial for each one of those 200 cases. It just doesn't. There's no way it would work. And you know, I know people are generally shocked when you say you got 80 cases or 100 cases, which is true. It's a shocking amount of number. But the defense attorneys here in the city, we make about the same amount of money. We have about the same amount of cases. And just like Tusk was saying, most of the cases, there's no way you can remember all the names. There's no way you can remember all the facts. But what you do have is just that, you know, a lot of times, especially with defense attorneys, I don't know if this happens where you're at, Tusk. We had great relationships with them, right? What about this guy? And a lot of our plea bargaining would happen because of those relationships, right? Hey, what do you got? And you know, it's sad to say, but most of the justice and most of the actual legal stuff that happens doesn't happen actually in the courtroom. It happens on the phone or via email, and then when you go to court, that's just the end of it, right? We've come to an agreement. Most of the stuff happens at a bar, in an office, you know, and that's the truth about the criminal justice system. It's not set up for justice. It's even though it seeks justice, it's not really set up for justice. It's set up to try to get through the tons and tons of cases that you have.
I was shocked the first time I heard. I was always defense. The first time I heard one of the senior partners on a phone call with the prosecution side on a case, and saying, well, we'll drop this guy if you drop that. We'll advise the court that we don't want to proceed if you drop the charges against this guy. And this kind of backroom dealing. And I was horrified, but then it became, okay, that's how it's done. You know, there's like, I mean, if you look at the court rules, I don't know if you can do it in America, but certainly in the UK, you can look up any court on the website, and it will tell you the names and dates of court cases. Won't tell you what the charges are.
Same thing here. Same thing here.
And a lot of time it will say administration. They're going to administrative court, which means the prosecution and the defence have sat down and went, we're not ready for this yet. We'll put it on the back burner. And people will show up to court expecting to stand trial. And 5 minutes before we'll be told, nah, go home, come back in 6 months. I'm talking to this guy, we'll see if we can work something out. And it may be they'll go for a drink afterwards. They'll hash something out, present that to the court, and then 6 months later, you'll get a letter saying, we are pleased to inform you that we no longer wish to proceed with this case. And you're going, what the hell happened? And it just so happened those two guys had a really good round of golf that day, and the prosecution decided not to pursue you.
Wow.
There's a question here. Can you ask the two guys whether they would advise a defendant to take a plea when they thought they are innocent? I suppose it depends on the case, wouldn't it?
Heavily, and you know what I used to, well, you know what? Well, two things. Number one, if I was a prosecutor, if I believe somebody's innocent, I'm going to go forward with the case. But as a defense attorney, I have been in a situation where I have had people who I felt were innocent, and they were offering the plea. And it's all about, number one, when the prosecution offers a plea to me, as the attorney, I have to give it to my client and let them know this is what's been offered, right? So I'm ethically bound to do that. And then I give my opinion on whether the person should take the plea or not. And generally, there's you have to evaluate what the plea is, how it's going to affect your life, and then what are our chances on going to trial? What evidence? Because simply put, it's not what you know, but it's what you can prove. Yeah. And if the prosecutor can prove something, even though we can feel whatever way we want to, but if they can prove something, then we have to kind of evaluate that. But most times, again, it's if someone feels they're innocent, but all the evidence says they're not innocent, then that's the client's decision. I'll say, I'll tell the client, hey, this is what we got. This is going to be my opinion based on the outcomes, but it's ultimately up to you because I'm not going to serve the time. It's going to be the client that's going to serve the time.
Yeah, if a client tells me they're not guilty, but the prosecution comes and offers a reduced charge or reduced sentence, if the convicting says, okay, you're going to go from like £1,000 fine to a £200 fine, but it means an admission of guilt. Now, I say I've got to look at the evidence and say, I feel you're innocent, but can I prove it? That's the problem, and I personally, well, I've never been put in that situation, so I can't speak to it from experience, but I don't think I would ever advise a client to accept a guilty plea or to make a guilty plea if I felt they were innocent, if there was any chance at all that I could prove that in court.
Yeah, even though here we don't have to prove the person's innocent. Like here we don't have to prove the person's innocent. But if I feel the prosecution has a strong case, then it sounds like we got to like I've had a couple of those cases where, hey, even if I believe you, but this case is strong as hell. We got to start thinking about it's not me and you, it's some rando who's going to be sitting in the jury box who's going to be saying, hey, what do you want to do here?
I worded that poorly. I don't go into a court trying to prove a client's innocence. It's up to the prosecution to prove their guilt. But, if I can frustrate the prosecution enough that they can't prove that guilt, then I would never advise a client to take a plea bargain.
The one time, I think the one time that I've had happen where I had someone who I believed was innocent, they took a plea, but the plea itself was not for a reduced sentence. It was we call it an ACD, an adjournment on contemplation of dismissal. So it's a dismissal. It's like a be good for 6 months, and then the case goes away. It's sealed. It's like it never happened. So that's like one of the only times that I've taken, because it was like, okay, do you want to go to court and fight this? Because at the end of the day, the result's going to be the same in either case, right? It's going to we'll win it, but now you've taken another 6 months of your life, or you can 6 months, it'll be gone anyway. So, but again, it really depends on that individual client, with their how much money they have, how it's going to affect their life, and whether they have a good deal, and what the prosecutors, because sometimes the prosecutor has a good case, that's important.
Yeah.
That's
So
been
the answer,
fascinating.
the answer to that
Sorry.
question is both yes and no, and neither at the same time, which is completely
Spoken like a
Yes,
true
no, and-
lawyer.
Yeah.
So,
Well, I tell you what, we definitely have to get you both back on for something at some point.
I'd love to get one of you on a debate for something of, I don't know if you do debates, but, something meaty and subjective, like death penalty. Do we agree with it? Something like that? If you ever fancy it, I'd love it.
yeah, absolutely, I'd like to do that.
Yeah, definitely. You got me.
Yeah, well, I know that you're setting up a different format for the debates, and I know
Yeah.
Kayla's been talking about it. Too many of the so-called debates we've had, neither party has shared their evidence with the other beforehand, and you can't have a debate like that. You can't formulate an argument if you don't know what your opposition is going to bring.
That's
Yeah,
true.
a lot of the flat Earth debates and stuff, people jump around from one topic to the next or crazy, and it becomes a case of what can I catch you out on that you've probably not prepared for, rather than what we're going to debate to get a final conclusion. It's like, maybe if I find this little corner of some obscure bit of science here, I can catch them out and show that they've not learned anything about it, and then I might win the debate. And it's not,
Again, this goes back to like the Hollywood version of law, where the prosecution pulls a witness out of the bag and they haven't told the defense. That never happens. You would never be allowed to do that.
You would get sanctioned for that, and in fact, that witness wouldn't be able to be showed. They wouldn't have that witness come up. It would be like, "What are you doing? Get the hell out of here!"
There's a comment there from Fiona Robertson says, "Great discussion would be juries and jury selection in the UK versus the US. That might be a good one to get you on."
Oh yeah.
Which system of law is better? There we go.
I've never sat on a jury. I'm not allowed to sit on a jury because I'm a legal professional. I'm not allowed to sit. It has to be a layman.
Yeah, so, I've done both. I've sat and I've helped pick juries, and it's interesting because it's interesting that it's interesting to see what people say to get out of jury duty. Like I've had white guys sit up there and say, "Yeah, I'm a total racist," and the guy just looks guilty. And you're like, "You're a school teacher, man. What are you talking about?" in the hood, like, come on, brother. Really.
The first firm I worked for, that was a jury choosing. You get to to a degree choose the jurors you want, because I don't want this person. I don't want this person. So somebody had sent their jury duty form back, filled in crayon.
I don't want that one. I don't want that one.
No, thinking that would get them out of it.
Yeah.
But they were hauled up in front of the sheriff and they were fined for contempt of court.
Oh, wow, you guys are rough.
Yeah, we don't mess around.
Wade Watts for $4.99 says, "I have found this fascinating, so interesting. Just thanks for the entertainment and so glad for the other people joining. Thank you for everyone." It definitely adds a different dimension having legal professionals come in on after the debate. So one of the things that I would like to see happen with this channel is that instead of relying on the large debaters who are established, is to actually give people a chance to learn how to debate. So that's what the Discord is for. If you want to learn how to debate and give a proper debate, then the Discord is where it's at. I haven't started the workshops yet just because work has just thrown me all off course. I'm sorry.
Real life gets in the way, doesn't it? Real life is a
It really does.
What did they say? Life's what happens when you're busy making other plans.
Amen to that.
Definitely. Well, guys, thank you, honestly, both. So, obviously, Tusk, I've seen you around in the comment sections, but I don't think I've actually spoken to you on a stream before, so it's a pleasure.
The first time we've spoken, yeah.
Yeah, and Tusk will be joining me for my live stream tomorrow with his partner. And it's live on the flip side, 12:30 British Standard Time. So what, 11:30 UTC? So yeah, brilliant. That's gonna be fun.
And Nate, big fan of your channel. I've enjoyed watching it blow up over the past year. So nice to finally get to meet you as well. And thank you so much for coming on.
Hey, thanks a lot, Ed. And I've been watching you guys. I'm a big fan of Crafty for a while now, so I'm glad to finally
making me blush.
It's true. You know, I've been in your chat. I've been I don't want to say stalking you, but I've been around like, oh, Crafty, I love you so much. So it's great.
We're fangirling over each other. It's okay.
Yeah, but whenever you guys want me, I'm definitely, because I love the debate. I love the talk. I know sometimes we've had some issues with the community, but other than that, this is fun. It's fun to meet new people and to have these conversations. I think they're important to have, and it's important to be able to talk to each other and stop talking at each other. You know what I mean?
Yes, absolutely.
Yeah, good point. Right. That being said, I just want to wish England good luck for kickoff in about an hour and 10 minutes.
Who are they playing?
We're playing the Ukraine in the quarterfinals of the European Championships.
We don't say that anymore.
I would like to wish Ukraine all the best of luck in football.
I've got my phone with me in case I get the call. Like, I need to get on at half time. I've got my boots clean in the car. I can be down to in no time. If they want me, I'm there.
There is a half joke in Scotland. We're asked, who do you support? And say, whoever's playing England.
Yeah. Patty, and we have Fiona all saying go Ukraine just because, I don't know. It's the anti-imperialist thing where you don't wish any problems on any British person, but when it comes to football and war, you're kind of slanted against them.
I mean, it would be great for the domestic game and sport in the UK as a whole if England won a major title. But you know what? I hope you lose, and I hope you lose badly.
You got to love the local derby attitude. No, it's fine. But I'm fairly confident about it. I might be wrong. I'm not confident about the whole thing, but I think tonight, we'll just about have enough. I think it'll be tight, maybe one goal in it, but I think we'll squeeze through. And like I said, if Gareth is watching, I've got my phone, you've got my number, buddy. I've got my boots clean. Just give us a bell, I'll be there, mate. So yeah, let's do it.
That I would actually pay to see. Fucking cats trying to run down a pitch. I would pay to see that.
Right, let's make it happen.
Yeah.
Right, on that bombshell then, should we wrap it up?
We shall. Guys, everyone who was on tonight, I will add their links to the description. So please do go have a look at them, check them out, give them a like, give them a subscribe. And thank you guys for being on. It really does make a difference to have people who genuinely know the industry and give us those insights.
Okay, well, thanks for having me.
Take care. Thanks again for having me too.
Thank you very much.
Bye, folks.
Right. See ya.